please?
Oh, I know. I'm stuck over here because of...
Please begin session on 53rd presiding.
Thank you. You may be seated. All right, welcome back, everyone. Thank you. Couple things. Page 53 has been replaced in your packet from when I went back and reread the portion after the specific elements of the case, and you'll see that that's been replaced. Furthermore, you may have noticed I may have missed a word or two, which is probably most likely a or a the or a then or these. You'll rely on the written instructions, not as necessarily how I read them. And also there were times where I may have read the caption or the title and not read them in others. Please don't take anything by that. I just maybe didn't want to, or I forgot, or whatever. But I don't want you to take any, there's no implication of why I did and didn't do it on one count and maybe not another. It just, so I just wanted to make those clear. So now we're going to proceed with closing arguments. We've concluded the evidentiary portion. This portion of the trial is the last chance in this process for each side to speak with you. It is at this point that they will make arguments about what they believe the evidence has shown, or in some instances what it has not shown. I will remind you, as I did during opening statements, this is not evidence, nor should it be considered by you during your deliberations. And with that, Mr. D'Angelo, you may proceed.
Thank you very much, Your Honor. Mr. LaPrinzi, Mr. Gorman, Mr. Riley, Mr. Ford, ladies and gentlemen of the jury. When I was a kid, I grew up in a neighborhood where our neighbors essentially were extensions of our family. As I've gotten older, I realized how lucky I was to grow up in such a safe, supportive area. Me and my entire family. And it wasn't just because our next door neighbor, Mrs. Fuller, made the greatest hamburgers in her cast iron skillet that you could ever taste, especially after a hard day of working on their farm. I was lucky because there was such a safe and supportive neighborhood. I was lucky to have grown up next to such safe and good people that taught my brother and I to work hard on their farm, that taught us all the value of having someone that was just looking out for you, someone that was just always there for you. Whether it was a heavy snow that came down, they were always there out there with their shovels shoveling our driveway. Whether it was we needed sugar or ketchup, my mom would say, just go over and get it for Mrs. Ford. Someone that was just always looking out for us. What is apparent from listening to the testimony of the neighbors of Stanley Ford in this trial at Fultz and Hillcrest is that they similarly appreciated the fact that they had someone that they felt, at least as he told them, was looking out for them, treated them well. What is also apparent is that those same neighbors did not see the two faces of Stanley Ford. The one friendly, nice, concerned neighbor, the one who claimed to be an angel of God sent to watch over the neighborhood, and the second face being the fallen angel who worked in darkness to murder those that he perceived threatened his community. The key question in this case is whether you believe beyond a reasonable doubt that this man, Stanley Ford, is the individual in those videos starting those fires at 719 Fultz and 693 Fultz, and that car fire at 723 Fultz. As Detective Looney testified to, in that second fire, the key is who was the man running down the street, and it was the defendant, in this case, Stanley Ford. And the key phrase in that statement, are you convinced beyond a reasonable doubt that it was him? So what is proof beyond a reasonable doubt? Well, the judge just read you an instruction of proof beyond a reasonable doubt, and I put it up here on my PowerPoint. It's not going to give you a percentage or some formula that you would type in numbers and somehow you get an answer. It does make its best efforts to try to get you all, as jurors, to relate it to your own lives, right? You're firmly convinced of the truth of the charge. It's based on reason and common sense. Reasonable doubt is not mere possible doubt. You're to rely and act upon it in the most important of your own affairs. When I talk about it with jurors, I sometimes like to give an example that I think and I hope explains it, gives it a different context. And I hope it does for you too. And it's a story about a boy named Johnny and this cherry pie that his mother made. The story goes like this. Imagine for a minute that Johnny's mother had to make this cherry pie for a family function. And she told Johnny as she was making it, "Johnny, I'm making a cherry pie. I know you love cherry pie. Don't touch it. This is for our family reunion later on in the day." She completes the cherry pie. He sits in the kitchen with her while she's making it all throughout the day. And when she's done, she takes it out and puts it on top of the stove. She tells Johnny, "Johnny, I'm going upstairs to get changed. Don't touch this cherry pie. Don't even think about touching it." She goes upstairs, gets changed, and when she comes back downstairs into the kitchen, she sees Johnny sitting on the kitchen floor with cherry pie filling all over his face. The cherry pie is gone, and he's laughing. Now, the question becomes, based on that, based on everything you've heard, is it possible that a neighbor boy came in while Johnny's mother was upstairs, took the cherry pie out of it, smeared it all over his face, tickled him, and ran out of the kitchen before his mother came downstairs, right? Well, I think we all certainly would agree that that's a possible scenario. The question becomes, when you're analyzing this definition of reasonable doubt, is that reasonable based on what you've heard? The question is not based on what is possible. It's based on what is reasonable, not some possibility based on some far-off scenario which you have no evidence of. In opening statement, I asked you to concentrate very hard, and I know each and every one of you was doing it. We watched. You all have paid very close attention in this case. I think you understand, and I know you understand how important it is. I asked you to follow the evidence before making your decision, and to consider everything, whether we presented it on behalf of the state of Ohio or if the defense did. Because in a case like this, and I think you saw after the May 15th, 2017 fire, when you heard that evidence, that this case came together like the pieces of a puzzle. Especially after that second fire, and especially after listening to the defendant's statements in this case. Is it possible that an unknown killer or killers decided to kill Lindell Lewis and Gloria Hart along with the Boggs and Huggins family on the same street months apart? Sure. Is it possible that the unknown killer or killers both decided to use arson as their means of committing the crimes? Wow, what a coincidence. But certainly, I would acknowledge that it's possible. Is it possible that those same killer or killers decided to start the fires in the same manner and on the same front porch locations in both homes? Wow. Is it possible that after those fires were started with accelerants, that the killer or killers all decided to run behind 1370 and 1374 Hillcrest, as you have heard, are the homes of this defendant? Is it possible that the defendant, who had widely known issues with Lindell Lewis, Gloria Hart, Thomas Hughley, just happened to be outside of his mother's home at 2:57 a.m. at 1374 Hillcrest on August 18, 2016, when an unknown killer or killers was attempting to set 719 Fultz on fire? Is that possible? Is it possible that the defendant, who also had issues with Nija Sands and her son, just happened to have left his mother's house at 2:01 a.m., as the alarm.com records show, all while an unknown arsonist was setting fire to Sam's vehicle sometime before 2:05 a.m. If you remember, that was when the 911 call was made, 2:05 a.m. So sometime before that, her vehicle was set on fire. Is it possible that the defendant, who had known and admitted issues with the Boggs and Huggins family at 693 Fultz, just happened to be outside at his mother's house and walking down Fultz at 2:43 a.m. while an unknown killer or killers set 693 Fultz on fire, killing 7 people, including 5 children, 4 of which are under the age of 18? Is it possible that he was out there and didn't see anything? Is it possible that this community man, who doesn't hesitate, as we know, to call the police, was out there when all of this was occurring? And then he made the decision not to tell the police about it? To not tell the truth about what he saw? Or I guess another scenario would be that the killer or killers, if it was one or many, all decided to run to his mother's house and disarm the alarms, and then run into his house, and he's still not going to tell the police about it? Is it possible that the defendant entered his home at 2:43 a.m. on May 15, 2017, took off his clothing, got in bed, and fell asleep before his wife woke him up to tell him that there was a fire down the street sometime before 2:46 a.m. when she called 911? Is that possible? Is all of this combined possible? Because it's not just each individually, ladies and gentlemen. In this case, to believe that it's not the defendant, Stanley Ford, who started these fires, all of these things combined had to have occurred. And I think you can tell from these rhetorical questions that I am posing. I would submit to you, and I'm going to argue in this closing statement, that added together, these scenarios are not even close to being possible and not remotely close to being reasonable. But let's go along with it. Let's talk about it. Could it all be an incredible coincidence? Could the defendant, Stanley Ford, be the unluckiest man in the world? Could that be possible? All of those things? Well, you've heard all the evidence in this case. I'm going to talk about it a little bit more in depth and break it down. In opening statement, I mentioned that there were 4 key pieces of evidence in this case, and I've added a 5th, the defendant's statements. Motive evidence, the alarm.com evidence, video evidence, the defendant's statement, and the timeline. And we're going to talk about each and every one of them individually, and let's start with the motive evidence. The 2 faces of Stanley Ford began to appear with the first witness in this case, Tiffany Gary. She testified twice, if you remember. An interesting character she is. She lived down the street from Lindell and Gloria, the defendant, and the Boggs family. She knew both of them. If you remember, she testified that when she would drive back and forth, she would see the defendant outside arguing with Lindell. She even told you she got out and started yelling at them. Next, you heard from Rebecca Wright. She was that nice lady that mistakenly identified Detective Looney as being the defendant. I think we all can tell from the photographs you saw when Mr. Laprenzi was asking Detective Looney questions, they both had similar hair at the time that they were arrested. An understandable mistake. She also told you the defendant was very nice to her and her husband, looked out to her. She knew of the tensions that were going on between the defendant and Lindell Lewis's house at 719 Fultz. She also told you that was a rough crowd there, rowdy crowd of people, men outside drinking. Beverly Ewing, another neighbor, she lived further down Hillcrest. She also told you the defendant was nice to her, told her, hey, I'm going to look out for you while your husband is gone. He told her that she believed that he was an angel sent by God to look over this community. Audrey Taylor, the nice lady who testified via Ring Central. She didn't come into play until we started talking about the second fire in this particular case. But she told you that, 1, the defendant had expressed anger and he was upset with one of the boys that lived at 693 Fultz because he was kicking cars, breaking mirrors off of cars. Now, this statement by Audrey Taylor was corroborated by the defendant himself. When you have a chance to listen to those statements again, you're going to hear, as you'll have them in evidence, that the defendant told Detective Looney that the boy was out there, or the boys at that house were bad, and they were out kicking cars. Miss Taylor was extremely authentic, and I think that's what really brought it home, even when she's singing when we're at sidebar. At one point, she told us that after the second house burned down, she was on her porch crying. Remember, she said, and she testified, I was upset because all these houses were burning down on my side of the street. I thought there was something more nefarious going on, and it was the defendant that came up to me and said, you're nice to people. You don't have anything to worry about. On one hand, on one face of Stanley Ford, that's a nice, reassuring compliment. Nice of him to say that. Make her feel better. On the other face of Stanley Ford, the other side, eerie foreshadowing. Glenda Gunn, another neighbor that lived next to Chester William on Fultz. She testified, they think I had something to do with this fire down there. The neighbor had cameras on my house, and I can go in my house when I want to. That is a quote and a statement that she testified to that the defendant told her after she heard all of the commotion outside of her house. She testified she heard a bunch of helicopters and things going on outside. So she went outside and she saw the defendant at the end of her driveway. She says, hey, Stanley, what's going on? And this is what he told her. They think I had something to do with the fire down here. Okay, I can understand that. But it's this second statement, ladies and gentlemen, that's so telling. A neighbor had cameras on my house, and I can go in my house when I want to. Why is that statement so telling? Well, it's because when you listen to his interviews that he gives to the police, he constantly responds to questions with what he's allowed to do. It's like he's like a child being accused of something, and instead of saying, wait a second, I didn't do that, when he feels like he's being caught, and when he does deny it, I'm not going to try to, we're going to talk about the statements, you're going to have them in evidence. He denies it repeatedly. But my point is when he says that, he's essentially acknowledging, one, that he was outside. What, I'm not allowed to walk down the street? What, I'm not allowed to go in my side door? It's almost like he's a child. And reason and common sense, ladies and gentlemen, tell us that that statement to Glenda Gunn and those statements to Detective Looney and Detective Bell are admissions. He's admitting, I'm outside. And we're going to talk about other things that he says in his statements and other admissions that he makes. But by saying that, he's not going on what someone else has told him. He's telling her, I was outside. Why am I not allowed to? Next, we heard from Chester Williams. His was the video that you all watched. He was the owner of the cameras at 714 Fultz. He told you he was friends with Lindell Lewis. And he put the cameras on his house because he wanted to help his buddy Lindell, friend Lindell. Mr. Williams told you that he had observed an argument going on, and he knew the tensions between the defendant and Lindell Lewis. And he saw an argument going on when the police were there at the scene of the house. He also told you that the defendant told him that he knew about his cameras there at 714 Fultz, an important point, right? He knew where the cameras were in the neighborhood. Mr. Williams testified, yeah, he came up to me and asked me about the cameras, and I said, yeah, I got these cameras up here. And he goes, yeah, I got to get me some of them. So the defendant knew about the cameras. Now, Mr. Williams was much more suspicious of the defendant than his neighbors. So much so that he put those cameras up. And he was also suspicious when the police were over at his house, if you heard from some of the detectives. He was pretty nervous when the police were at his house downloading the footage. He told them he wanted to have the cameras up right away. The point of all of these witnesses is to show the obvious animosity between the defendant and the residents of 719 Fultz. I think that that has been shown by multiple witnesses. We also heard from Nija Sams. She lives at 723 Fultz, and she testified that her car was set on fire on January 23rd of 2017. She also testified that a few days prior, that the defendant was outside yelling at her son, Devontae Ware, about walking through his yard. Nija told you that she heard the defendant tell her son, "I will body you," and an argument ensued. Now, she also said that she didn't think anything of it when her car caught on fire 2 days prior. She didn't put two and two together that it was the defendant who set this car on fire, not until May 15th of 2017 or 18th of 2017 when they're searching his house and accusing him of setting the other house on fire. That's when she started to put it together. The point of all of this is to show to you all as jurors that when you're a nice neighbor, when you're a quiet neighbor who doesn't bother anybody, as he told Audrey Taylor, you have nothing to worry about. I can tell you the defendant would have liked Mrs. Fuller. She was one of those neighbors. But when you cause trouble, when you're loud, obnoxious, and rowdy, you have a lot to worry about in Stanley Ford's neighborhood. Mind you, this motive evidence, ladies and gentlemen, by these neighbors was all confirmed by the defendant in this case, in the statements that you will have with you when you deliberate. Some of them are hard to listen to. Probably got to listen to them again, especially that first one with Detective Stewart. But these are the statements, and we're going to go over them all in more detail in a few minutes, but these are the things he is telling the detectives. All confirming what those neighbors had told you. That he had problems with Lindell Lewis, Gloria Hart, and the Boggs and Huggins family. I mean, he said it, and you'll hear it in one of his interviews. The neighborhood's changing. Ever since Mrs. McGinnis lived here and she left, it's bad here, is what he says. Now, the defense in this case has pointed to several suspects that they claim have independent reasons for wanting to set 719 Fultz on fire and 693 Fultz on fire. Without a doubt, there are other suspicious characters in this story. But before we talk about each and every one of them individually, I just want you all to consider this. Each person that the defense points to can be eliminated from suspicion based on the evidence that we have and we developed against the defendant, Stanley Ford. Is there any evidence that these suspects have any connection to the defendant? Is it just a crazy coincidence that they all would run behind his house? Do any of them know his alarm codes other than him and his wife? Why would they be going into 1370 Hillcrest? Why would he not tell us about it? So let's take a look at these suspicious characters. The first being Francine Lewis and William Pryor. Francine Lewis, if you remember, is the ex-wife or former wife of Lindell Lewis. She was suspicious. Detective Stewart testified to you that she was suspicious of Francine Lewis and William Pryor because they were acting suspicious at the scene. She told you that. She also said that there was a life insurance policy involved. Detective Stewart told you that she later learned that Lindell, Francine, and William would all go on cruises together, though, after the fact. Okay. Next is Ronald Garrett. He acts suspicious during his interview with Detective Stewart. She just said she didn't feel right when she talked to him. He was being deceptive on some other points. The question I have about him is, why is he going to burn the house down that has all of his belongings inside of it? The drug dealers of Ronald and Thomas Hughley. Mr. Gorman talked about them, asked Detective Stewart about them. Do we even know who these people are? John L. McLemore, another person. This guy set Lindell Lewis's car on fire in the side of his house in 2014 or 2015. You heard from Mr. Hughley, his testimony that was read into the record, that happened, that Lindell was upset about it, but they had made amends. They were friends again in April of 2016. The men in the truck. 2016 has this truck driving up and down Fultz Avenue. You'll remember it. You'll see it again when you watch the narrative presentation and the video presentation. The truck is repeatedly going up and down Fultz. We see that truck later on show up at the Circle K gas station on East Avenue. Surely, this is strange. Strange activity. Tiffany Gary, if you remember, testified in this case that truck belonged to this house right here. As I'm pointing to it on State's Exhibit 14, that's where she said that truck belonged to. She would see it there all. She also tells you that those people that lived at that house were involved in drug activity. Okay. Now, when you look at the video from the Circle K, it's pretty obvious, I believe, unless the person here, who I am going to argue is the defendant, is not wearing anything similar to the men we see at the Circle K. I mean, unless the argument is that this person stayed inside of the truck at the Circle K and never got out. Okay. But we can infer that these two, based on these photographs, is not the same as this person here, who is the defendant. In addition, when you look at the third and final attempt of the truck on the other end of Fultz, and you can analyze and study this, and I'm sure you will, in the narrative presentation and the video evidence. But you'll see, and we're going to talk about my timeline a little bit more later. But at 3:28 a.m., you're going to see in the narrative presentation and in the video evidence, the truck turns around at Fultz and Hillcrest and heads towards Height. So it's turning around here at 3:28 a.m. and heading towards Height. Right at that point, you will see the front door open to 1374 Hillcrest, the defendant's mother's house. And you'll see the light reflect off that front door. That is 5 minutes later, you will see the tail light darken at the driveway of 1374 Hillcrest and the individual attempting to start walking down Fultz towards 719 Fultz for that third fire attempt that caused the fire, that started the fire. So pay attention to this timeline. I believe that, ladies and gentlemen, I would submit to you that eliminates this truck's involvement. Because we know when the light is reflecting off the doorway, that truck is also turning around. Now, after fleshing all of this out and hearing all this evidence in 2016, we can kind of understand why Detective Stewart was very cautious about making any arrests, right? There were a lot of shady characters hanging around at Lindell Lewis and Gloria Hart's house. There was a lot of people who were doing some strange things. But ladies and gentlemen, let's be very clear. The defendant was still on that list, right? You heard, and you're going to hear again, the interviews that Detective Stewart had with him at the front door. It's a hard one to hear, but you have to listen to it hard. And then that second statement, or that second interview that when she calls him and it's on the phone. And as she testified, her opinion began to change. Even though he was on the radar, after that second fire in 2015, her opinion started to change greatly. She testified that it was only then, that she knew anything about the alarm codes at 1374 Hillcrest. It was then, after she had listened to the interviews with Detective Looney and Detective Bell, and the statements were sort of almost exactly the same as he made to her. It was then that when she went back and looked at the video again, she saw movement in the driveway of 1374 Hillcrest. That's what Detective Stewart told you. She got more information, and she made the conclusion that it was the defendant. Now, in the 2017 fire, the defense pointed to additional suspects, but within great emphasis, they pointed to this person, Patrick Boggs, with understandable, that's very understandable, right? Hey, the police took him into custody, right? Right after that second fire, the police took him into custody. Why? Because he set Angela Boggs on fire 12 years prior. Or he set her on, I'm misstating that in my PowerPoint. He set her on fire greater than 12 years ago, because we know he was sentenced to prison for attempting to set her on fire for 12 years. Okay, so he was in prison for that. We also learned that while he was in jail, he made statements to this Selby, this inmate, this jailhouse informant and jailhouse bunkie of his, about setting 693 Fultz on fire. We also heard that Selby said that he was a racist. He didn't like the idea of Angela Boggs being with a black man. Now, Detective Looney testified in this case, and he said that he was able to eliminate Boggs because of his cell phone never left his home in Ravenna, never left those cell tower areas. That's what he testified to. He also testified that he watched the video from his apartment complex, and it shows that Boggs' vehicle never left. Detective Looney said he watched hours of video, I believe were his exact words, and his vehicle never left. In addition, inmate Selby, who, remember, he says, and I want to get it right, inmate Selby said that Boggs told him that he started the fire using the barbecue grill on the porch of the house, and he put hot coals in a plastic garbage bag, and that was how he started the fire. That's what Selby said Boggs told him. Well, Detective Looney continued to investigate that, and he learned that that is not consistent with the physical evidence in this case. First, the fire did not start on the porch with the charcoals in the plastic bag. It started on the side of the porch. In 2016, investigator Peterman testified based on his expertise, and he was an expert in this case, back in that 719 fire, that the canine alerted at the corner of the porch. Remember placard number 2? He testified that he could tell, not only from that canine alerting there, but based on the burn patterns on the side of the house, that that's where the fire started. Sure enough, he was right. We see in the video from 719 Fultz that that is exactly where the fire was started. In the 2017 fire, investigator Peterman told you that the canine alerted right where those garbage cans were located, in the corner of the porch, on the outside of the porch, not on the porch. That's where the canine alerted. He also testified, again, based on the burn patterns, that he could tell where the fire was going and where it started. And another important point, ladies and gentlemen, is he told you that if the fire would have started on the porch, the garbage cans would not have melted to the ground. You'll see in the pictures, and you've already seen, that the garbage cans are down to the ground, completely melted. So, ladies and gentlemen, to believe that Patrick Boggs is the murderer in this case, we have to do this. We have to believe that Boggs decided to drive to Akron at 3 a.m. to set his ex-wife's house on fire, and was smart enough to leave his cell phone at home. Okay. He does this while not using his own vehicle. And for some unknown reason, he decides to run to 1374 Hillcrest. Because without a doubt, we know from Chester Williams' video camera that when that fire starts with a flash, he runs by his house. And that flash, that's one last thing I want to talk about. Investigator Peterman told Detective Looney, and you heard through Detective Looney's testimony, that charcoal inside of a plastic bag smolders. It's going to smolder and then catch fire. You're not going to see a flash, right? So Investigator Peterman knew when he saw the flash in the corner of the porch at 714 Fultz that an accelerant was used, much like in the first fire at 719 volts. So, back to this. Patrick Boggs is the murderer. To believe that, for some unknown reason, he runs by 1374 Hillcrest and goes into his mother's house, the defendant's mother's house, and unarms and arms the alarm system. And then Patrick Boggs, we have to believe, is the one coming out of the house and going in to the defendant's house at 1370 Hillcrest? Or is it the defendant that's outside? I guess that could be another scenario, right? The defendant is outside, and he sees Patrick Boggs starting the fire there at 693 volts at the corner of the porch, and he decides to run back to his mother's house. Well, why in the world would he decide to tell the police that he was asleep? If there's one thing you're going to hear in that interview is that he was asleep. He said, "I was asleep. My wife woke me up and said, Stanley, there's a fire down the street." Why would he say that if he saw someone set the house on fire? Detective Looney followed the evidence in this case. Boggs then decides, ladies and gentlemen, this is to top it all off, to go to the Portage County Jail and tell inmate Selby how he started the fire, but only do it incorrectly, right? I mean, why is Boggs telling Selby that he started the fire in the wrong way? It makes no sense. It's not possible that Patrick Boggs is the murderer. Now, the defense has pointed to a whole host of figures. They also pointed to black cars and even the defendant's own son, Stanley Mitchell. They've even inferred that it could possibly be one arsonist that set both of these houses on fire. I actually agree with that point. There was one arsonist that set both of these houses on fire, and it was the defendant, Stanley Ford. I mean, who else had motive against both houses? Who else would run to his house? In the end, the defense, in their motive evidence that they're pointing to, is asking you, ladies and gentlemen, to forget everything that we have on the defendant. Forget all of the other evidence we have on the defendant. Close up shop, go home, because possibly one of these other people could have done it. Possibly. It could be someone else. That's not the standard. The second key piece of evidence I'd like to talk to you about is the Alarm.com evidence at 1374 Hillcrest. As I'm sure you remember, these Alarm.com records only apply to 1374 Hillcrest. Detective Looney testified that he did look for alarm records at 1370 Hillcrest, and there wasn't any. He also testified that the key holders in this case, registered with the Akron Police Department, were the defendant, Stanley Ford, and his wife, Zaneta Ford. When examining these records, please note the following. First, the only code that we see entered at 1374 Hillcrest in this State's Exhibit number 40 are alarm codes associated with the defendant, Stanley Ford. Next, the defendant uses the armed stay and armed away functions. Jason DeCasso from Alarm.com told you and described what those mean. Just to review it, he said being armed away means that you're arming the alarm, all the sensors inside of the house are activated, right? So if you stay in the house, you're going to set the alarm off. He also said that arming stay means that only the exterior sections of the house are armed. So you theoretically could arm the alarm and stay in the house without setting off the alarm. He also testified, though, that you could arm stay and still leave the house. And if you remember, he gave an example. He said, yeah, I do that a lot because I have a dog inside of the house, right? And so if I arm it away and leave the dog inside, the dog's going to set off the alarm. Now, the defense has pointed out that even though the records show that the alarms were disarmed by Stanley Ford that we can't tell exactly who is punching in that code at 1374 Hillcrest. That's a good point. I agree with that. We don't know exactly who is punching in that code. But we do know, one, that the alarm, the key holders are either the defendant and his wife. Two, that the defendant tells Detective Looney that he is the one, he and his wife are the only ones who have the alarm codes. We know from his statements to Detective Looney that no one else should be going inside of those houses, his house or his mother's house. We also know that based on the video evidence, we only see the defendant leaving 1374 Hillcrest. These records are a crucial piece of the puzzle in this case. They not only show his identity, but they show that the defendant has opportunity to commit these crimes on all three occasions. On all three occasions, he's arming and disarming the alarms within minutes of the fire starting. Mr. Gorman pointed out on cross-examination of Mr. DaCosta that, hey, you know what? These alarms they're armed and disarmed all the time in the middle of the night, right? You know? What does that mean? So what that they were disarmed on the 3 nights of these fires? Well, ladies and gentlemen, I'd argue to you can't have it both ways. You can't say, well, hey, you know what? Stanley's out all the time in the morning. He's going over there all the time. Well, we can't infer anything from that. But then say, that's not Stanley on the 3 most important days in those records. On April 18th, January 23rd, or May 15th. You can't say, well, it's him all the other times, but not him on the inconvenient times. Our reason and common sense says that you can't have it both ways. Those records identify the defendant in this case. The next piece of evidence that I pointed out is the video evidence. In 2016 and 2017, from Chester Williams' house and from Lindell Lewis's house. Probably the most important pieces of evidence that you're going to have in this case. You're going to have them in the form of the narrative presentation that Mr. Barkhurst prepared, and also the video presentation for both fires. I encourage you, and I'm sure you will, analyze them very, very circumspect. Look at them. Study them. Now let's talk about that first fire. There's a ton of movement in this first fire, right? I mean, we have cars pulling down Fultz. We have cars going up and down Fultz. We have cars stopping at the end of Fultz. We have people walking up the side of 719 Fultz, the defendant. We're just going to say is the defendant. We have people spraying liquid on the side of 719 Fultz and lighting it on fire. We have, in that second attempt, right, we see that second attempt, the person who lights 719 Fultz on fire runs down the street where that car had pulled down the street, stopped, and turned off its lights, right? Then the lights turn on. The reality is in this case, ladies and gentlemen, we don't know what kind of car that is. We don't know if that car has anything to do with this case. It may. And if it does and we find evidence of it, we will prosecute them. If they're helping out the defendant in this case, we will prosecute them. But we just don't know. But what I'd like to point out, too, though, is when you watch the narrative presentation and the video evidence, very clearly in that third and final attempt, and we've highlighted, you're going to see this timeline, we're going to talk about it more in my closing argument towards the end. This is all the activity you're going to see, but when you watch that third and final attempt, there's no vehicle at the end of Fultz. The first thing we notice at 3:33 a.m., the tail light darkening and an individual walking down Fultz. Approaching Lindell Lewis's house, lighting it on fire. Then we see the tail light darkening again in the driveway of Stanley Ford's mother's house. There's no other car. There's nothing there. We don't know, could that have been a fluke in that second attempt? Could that car have just been turning down there to stop and wait for someone and they were startled when someone was running up to it? Could it be an accomplice? All things we just don't have evidence of. And like Mr. Loprinzi talked about in voir dire, that's an important point. You absolutely have to go on the evidence in this case. What came from the witness stand? You can't rely on what I say, an opening statement, or certainly in this closing argument. You can't even rely on our questions that we ask. You have to go on the evidence. As I said in opening statement, if another person's involved, we'll prosecute them. In addition to the video from 719 Fultz, we notice that, as I said, Mr. Peterman said, the fire was clearly started at the corner of the porch, corroborating his opinions on the burn patterns and the dog alerting to number 2. And we also see from this video from Chester Williams' house, the defendant runs behind his house. In the 2017 video, the first thing I'd note when you watch the narrative presentation and the video presentation is that at 12:50 a.m., we see a car leaving, driving down Fultz, right? When you're going to watch it, you're going to notice that there probably was some sort of a party going on Fultz Street. The car leaves at 12:50. And at 12:58 a.m. is the first time that we see movement at 1370 Hillcrest. Some 8 minutes after the final car leaves, and we see that the panel is disarmed by Stanley Ford at 1374 Hillcrest some 2 minutes later. Man, does that seem like a guy who watches out for his community? Who's paying attention to what's going on outside? Keeping an eye on it, as he said. In the 2017 video, as Detective Looney testified, he infers and he makes a conclusion that if he could tell who this person was after that flash occurs, who this person was, running by 714 Fultz, Chester Williams' house, and into Stanley Ford's mother's house, coming out minutes later, arming the panel at 2:43 a.m., and then entering Stanley Ford's house at 2:43 a.m. at 1370 Hillcrest, when Angela Boggs is calling 911 to plead for her life, that's the person who started the fire. That's what Detective Looney concluded. And the defendant tells him on May 18th, if anyone is coming in my side door, it's me. I can't give you no good reason why I went down there. That's what he tells Detective Bell and Detective Looney. I forgot why I went down there. That sequence we're going to talk about again. It becomes hugely important in this case, especially when you consider the statements that he made. Last thing I note from the videos is, in 2016, ladies and gentlemen, the defendant claims that he was asleep. Now, he does describe that his window is on the opposite side of 1370 Hillcrest. He was asleep in the house, but he also tells Detective Stewart that his window is open because the weather was nice outside. You're going to hear him say that. But he doesn't hear, smell, or see this yards away from his house? Okay. I mean, maybe he's a heavy sleeper. I don't know. But that's unreasonable to me. Secondly, he also says, if anyone's coming in the side door, then it's me in the second fire. Now, next I'd like to talk to you about the side-by-side videos that Mr. Barkhurst prepared and that you saw in this case. You can judge for yourself, based on those videos, whether the person walking in these videos is similar to the walk of the defendant, which was taken when he was interviewed on May 18, 2017. Now, this side-by-side was not done. This is comparing the video to the 2016 video. These are just still frames that I put. But please notice when you're watching this video that the pace is the same and that he swings his arm. The person in the video in 2016 and the person in the video in 2017 swings his right arm, much like the defendant, in this case Stanley Ford. Ladies and gentlemen, I tell you that the pace is also important. Their pace as they're walking is very, very similar. These videos prove his intent. These videos prove, and you saw on 3 separate occasions, someone tried to go at a 719 Fultz and set him on fire. And you heard in the jury instructions, one of the elements that Mr. Laprinzi and I are required to prove to you, beyond a reasonable doubt, not only that it was the defendant, but that it was his prior calculation and design to cause these deaths. Reason and common sense would tell us that when you set a house on fire at 3:30 in the morning for a man who is walking using a walker, that he's not going to make it out. That he's going to not make it out of the house fire. We heard from Tiffany Gary that Linda Lewis and Gloria Hart were screaming from that window that I have circled there. On May 15th, 2017, you're going to see the defendant walk around the neighborhood, but we see 3 separate times he runs up Fultz back towards 1374 Hillcrest. The 3rd time being, moments later, we see the flash from the side of the porch. The 911 call soon follows. We know the fire is going. But 3 times we see him running up Fultz. It'd be one thing if, that first fire, he's like, look, I got to get Linda and Gloria out of here. I'm just going to set their house on fire. Maybe they'll get out and, then they can move. But they didn't. They died. He was interviewed, and he got away with it. And then months later, when the neighbors down the street are causing him problems, he goes and sets their house on fire? There can be no doubt at that point, ladies and gentlemen, that his intent, his plan was to kill them. All 9 of these people knew they were going to die, the evidence has shown. And so did the defendant, because that was his plan. Even if we somehow make that assumption that was not, and that's a big assumption, that was not his plan in 2016, it definitely was his plan in 2017. Next, I'd like to talk to you about the statements that he makes. The 4th piece of evidence in this case. I'm going to review a lot of what he said, and you will have time in the jury room to deliberate them. And please understand, you're going to have them with you. I'm not trying to take him out of context when I highlight these statements. Please listen to them carefully. But one time, I was told that reason and common sense can be described like this. Reason is in your head, common sense is in your stomach. Just in listening, if you draw nothing else from the defendant's statements, just in listening to them, you're going to start feeling it in both. It just doesn't make any sense. Why is he being so evasive? Why does his story start to change as he's given more information? Why, as Detective Looney points out, you'll hear this, Detective Looney says, you keep trying to misdirect me. Why does the defendant keep doing that? Something is just not right. In the 2017 interviews, you'll notice his ability to recall events as they go along, but then he can't remember. I can't recall what time I took out the TV. I can't recall what time I went to go get the lemon balm. He can't remember 3 nights prior. A night that would be pretty significant, right? I mean, that's the night that someone set a house on fire yards from his house, killing 7 people, including a bunch of children. And you can't remember until you get caught. And then you start making up a story. And you don't want to be too specific, because you don't know everything that they have on you. He has to misdirect, because as he said, I had no good reason why I was down there. Understatement of the year, ladies and gentlemen. His evasiveness, his misdirecting, I submit to you, ladies and gentlemen, is obvious. Let's examine those statements. First, you heard from Ellis Polk, the fire investigator from the Akron Fire Department. He told you that the defendant told him that Lindell Lewis was a vicious guy, that he had buddies sitting on his front porch drinking alcohol. that Lindell had prostitutes working out of his house. Next, we're going to hear the statement, and you'll have this audio in evidence, that he gives to Detective Stewart at his side door with Sergeant Litke there. If you remember, they point out when they're talking to him, "Hey, Stanley, we're talking to everybody like this. There's no reason for you to be this nervous." First thing he says is, "I was actually kind of like I was working out and I was kind of sleeping when the fire starts." Next, you'll see and you'll hear, you have to listen to it hard. "We had the window open because it was nice weather. I don't want you guys interrogating me like I did it. Them guys are bothersome to everybody. Tommy tried to break into my mom's house," which we also heard from Mr. Hughley. "They drink a lot, smoke a lot of weed. They are on crack. This guy with the bald head over there, I asked him to let me out, to take my daughters to school. He told me he said you was harassing them." That he was harassing the bald guy. If we saw the photographs from Lindell Lewis laying on the bathroom floor, he's the bald guy, ladies and gentlemen. Next, he tells them guys, they try to get me to come engage with them. This is in the telephone interview that you'll have in evidence. Them guys was nasty. They had prostitutes in and out all night. They was dealing in homosexuality. "You all had me so scared. I best take me and lock me up. You know what I mean? You all have me jerked up, man. Those people were just some bad people. I don't do nothing to them people. Them people was just mean. When they moved up here, Tanisha, they stole everything that wasn't bolted down. They stole everything from people, everything. Does anyone stay at your mom's house?" That was a question that was posed to him. "No, nobody stay. I take care of it for the family. One of them guys wanted to see how long my penis was." Finally, he says, "We ain't never experienced this up in this neighborhood because it's a bunch of older people. And you got an old lady retired. My mom was one of them. You know what I mean? When you come in there, you learn to respect and you look out for them. I would never have been friends with them because of the standards I have now." In 2017, his interviews start. Detective Looney, you will hear, and you saw, he testified, they start to go to his house. They start to put some pressure on him. "Hey, we see this guy again running behind Stanley's house. He's certainly a suspect." You're going to feel, you can almost feel it when you listen to him, the pressure starting to build on him. He knows they're coming. "It's just after my mom, man, like the older generation died, this whole neighborhood has changed." "Do any other adults stay with you?" No. "Sometimes I try to get sleep during the day, and then I try to be up at night watching. I try to keep an eye on the neighborhood, actually, man. I try to be watching the neighborhood." There's a lot of people. And now, ladies and gentlemen, just to be very clear, he's talking about the folks at 693 Fultz. They have a lot of people in that house coming and going. I ain't, and that's scary. When you're up here in the neighborhood and you got these different faces coming and going, you don't know, and then they disappear, It was like two skinny, tall males in there just a couple of weeks ago. They just poof. Paul was telling me one of them boys tried to poison his dogs. They had some bad people up in there. They just some bad people, from what I observed with some of the stuff they was doing in the neighborhood. Once again, he has this complex of being pursued. I feel like I'm a suspect. No one stays at 1370 Hillcrest other than him, his wife, and his 2 children. No one has keys to his house, not to my knowledge. I was asleep. This becomes very, very important. Because based on the timeline that you'll see in the video and narrative presentation, he says he was asleep. She woke me up and she just said, "There's a fire, And I got up and looked. She woke me up. At any time did you go outside? No. I took the TV out long before the fire. There was no fire. This neighborhood has changed since my mom. And like I said, Mrs. McGinnis and the other people was here. They had the neighborhood watch. It was a better neighborhood. The kids was good. But now it's transition to renters and stuff like that. It's bad, man. I thought those kids, referring to the ones at 693 Fultz, were bad. Shit. Like what? Like what, Stanley? Well, shit, like kicking vehicles, rear view mirrors, busting them out, and stuff like that. Just like he told Audrey Taylor. I don't know them, but you know what? I keep an eye on them. I know what's going on in this neighborhood. That's what I know. I was sleeping. She woke me up. There's no way you were outside? No. Nobody came over? Not to my knowledge. Did nobody come over to my house, man? Not to my knowledge. Did nobody come over to my house, man? That's what he says. Did you come in the house right before the fire? I don't believe I did. I don't believe I do. If I was out and I went in and there was a fire, I didn't have any knowledge of it. Nobody come in and out of my house before no one did no fire. I can't really recall too much. This is where the recall comes in. I can't remember. I can't recall a fire going. And if anybody coming in my side door, that's me. If anyone came in that side door, it was me. This is when he starts to change a little bit of the story. Now, if it's me back there, the backyard, if it's me going in there, I didn't see no fire. Because at this point, I think he's realizing, they keep asking him, why are you outside? Why are you coming in the house? In the story, he feels like he needs to start explaining it. If you got me on camera doing that, coming in the house, there wasn't no damn fire. There wasn't no fucking fire down there. I'm telling you guys the truth. There wasn't no fucking fire down there. Why were you going down that way, down Fultz? And remember, I talked about this earlier? Just like he says to Glenda Gunn. What, I'm not allowed to go down Fultz? That's an admission, ladies and gentlemen. He's admitting he went down Fultz. Listen, I can't give you no good reason why I went down there, about there. But listen here. If you guys got real cameras, if you got me walking down there and walking back, guess what? There wasn't no fire. Why did you go down there? Why did you go down there? They keep asking him. Why did I go down there? I forgot what I went down there for. You mean you don't know why you went down there? Probably down there, minding my own business. Reason and common sense, ladies and gentlemen. What are these statements telling you? Why were you walking down Fultz at the time of the fire? If you saw me walking down there, I mean, just if I'm walking down there, I'm free to walk, man. What did you see when you were down there, Stanley? It was pitch black. It was pitch black down there. There wasn't no fire. Now he's acknowledging he was down there. Where moments before he was asleep. The final piece of evidence I'm going to talk about is the timeline that you have seen and we have put together. You're going to have this in evidence with you in the form of those large poster boards. And I do believe, ladies and gentlemen, this is a helpful piece of evidence. You can use it as you may. You can disregard some portions if you don't agree with it, if you don't feel that that's what the evidence shows. That's your prerogative. But it does outline the evidence as we go through it and the things that it puts together. You can add to it, do what you like. But the timeline in this case, ladies and gentlemen, it shows a couple of things. Starting here at 2:56 a.m. It encompasses the alarm.com records, and it encompasses the events as the night moves forward. Tail lights darkening, lights reflecting off doorways. You remember lights turning on inside of 1374 Hillcrest. And the final events in 2016. They show his intent. I'd submit it shows his modus operandi, or MO, or his method of doing things, how he operates. It shows his identity. When you put all of this together, it shows, when you compare 2016 to 2017 timelines, his fingerprint-like actions that come back to only him. It's his signature. That, combined with the events of January 23rd, 2017, it once again shows his identity. Nigel Ware's vehicle set on fire. The defendant's Alarm.com records show that he had logged out of his mother's house at 2:01 a.m. At 2:05, the 911 call comes in. 2 days later. It's his identity. It's his MO. It's his calling card. He gets angry. He comes out in the middle, he gets angry at a neighbor. He comes out in the middle of the night. He goes over to his mother's house. He arms and disarms the alarm, and then he burns her property. It also helps us put his statements into context. Here are the alarm records from January 23rd. 2:02 a.m., he is arming the panel. So the 2017 timeline I had mentioned helps put his statements into context. You're not going to see lots of other people walking in this timeline, and I don't think you'll see in the videos. You don't see cars coming up and down the road. You don't see cars stopping at the end of Fultz. We just see Stanley going over to his mother's house, arming the alarms, disarming the alarms, turning the lights on. We see him darkening the taillights in the driveway. We see the light from the porch. We see all of this right here at 2:42, 2:43 a.m. When the defendant says he's asleep, his wife calls 911 at 2:46 a.m. The defendant says he was asleep. Are we to believe, ladies and gentlemen, that he went in his side door at 1370 Hillcrest, got undressed, went upstairs, fell asleep, and his wife woke him up? He said he was sleeping in his underwear. He also said his wife called 911 several times that the call was dropped. That's what he told Detective Looney. Is that possible based on this timeline? It's not even possible, let alone reasonable. I'd submit that that story is what Mrs. Fuller would call slicing the bologna a little thin. To believe that story and to believe that it's anyone else other than the defendant in this case, you would have to be suspending your reason and common sense. Why is he not telling the truth? You have to believe that it's not Stanley Ford, that he is the unluckiest man in the world. Or, ladies and gentlemen, is it a much simpler scenario? He did it. The defendant did it. In opening statement, I mentioned this key sequence of events that is devastating proof of his guilt. You saw this, we saw it just earlier. The light and the side of the porch in 2017, Stanley running by Chester Williams' house into his mother's house, arming the alarm, entering his own house. If anyone's coming in my side door, it's me. I can't give you no good reason why I went down there. It is devastating proof of his guilt. If you're convinced beyond a reasonable doubt that that's Stanley Ford, this story is much easier to understand. We don't have to strain our reason and common sense anymore. One arsonist, Stanley Ford, who is beefing with his neighbors, leaves his house during the early morning hours and sets their property on fire and kills them. 9 people. That's what happened in this case. This has been a long and difficult 2 weeks for you. You all didn't ask to come in here and serve as jurors. As Mr. LaPrinzi said, you probably thought you were coming in to serve on a theft case. I can tell that each and every one of you has been paying diligent attention to the evidence in this case, and I thank you sincerely on behalf of myself, Mr. LaPrinzi, and Sherry Bevan Walsh, the Summit County Prosecutor. If you've noticed that criminal trials focus on defendants involved in them, and they should. They are also a search for the truth and for justice. And unfortunately, in homicide cases, they are also an accounting of the last moments of the victims' lives. All 9 of these folks. It's an accounting of what happened to them and how they lost their lives. Your work, not only in listening to the evidence in this case, in analyzing it, and in your deliberations is important, not only to the defendant, Stanley Ford, but also to all of these people. Is it reasonable to believe that the defendant is the unluckiest man in the world? Is this all just a horrible set of coincidences? Is Stanley Ford just that unlucky? Is he snake-bitten? Is he star-crossed? Our reason and common sense tell us that he is not. So what does that mean? It means he's our worst nightmare. He's a fallen angel who operates in darkness. And the irony of it, ladies and gentlemen, is that his identity was exposed by the very light from his most horrific act. The light from the fire of 693 volts showed us who the arsonist is, who the murderer is. Find him guilty and hold him accountable. Thank you.
Thank you, Mr. D'Angelo. Okay, ladies and gentlemen, again, in an effort not to split everything up,
We're going to take a short 10-minute break, allow you all to use the restroom, stretch, and then we'll finish with Mr. Gorman's closing arguments and then rebuttal by the state of Ohio. I want to remind you of the admonition. I know you feel like we're getting there, and I promise we're going to. But you have to remember that the previous admonition I've given you at all of your breaks concerning your conduct. Again, it's important that you be fair and attentive. Do not discuss the case amongst yourselves or with anyone else. This includes family, friends, and the media. You must not post or read anything about this case. And any such discussion, if you talk about it, if discovered, could lead to a mistrial, which would severely compromise the party's right to a fair trial. Do not permit anyone to discuss it with you or in your presence, and do not form or express any opinion on the case until it's finally been submitted to you. So leave your notes and your jury instructions upside down on your chairs, and then if you'll be back in the jury room just after 5 after 2, we'll finish up the closing arguments and concluding instructions.
Do they need to stay there since there's a question?
Yes.
All rise, please. Please stay in the jury room area.
need to do this too, Your Honor.
Yeah, that's fine. Yeah, I'm waiting, because I gotta wait for council to come back. Sorry, I was like, oh, you've done this, oh, it's taking a break. So I summoned him. They're all right here. They are. but I don't think they're one. I don't know, we'll see.
Stanley County Court of Common Pleas is again in session. Honorable Christine Crouch, presiding.
Thank you, you may be seated. All right, Mr. Gorman, you may proceed.
Good afternoon, everybody. Attorney Riley and I, throughout the course of this trial, and I know we started way back on August 16th, I think that's when we met you folks. We've, as the prosecutors have paid attention to how you're receiving evidence, the attention that you're paying to this case. And we want to, on behalf of our client, thank you for the energy that we can feel that you have brought to the table in this case, this very, very important matter. As I said in voir dire, this is the most important weeks of Mr. Ford's life. And I know the prosecutors will say, well, this is the most important weeks for the victims as well. But they're not on trial right now. Mr. Ford is. The burden of proof in this case, folks, let's not forget, because I heard a lot of shifting going on with the prosecutor's closing argument, telling us why the burden's over here and the suspects are no good, and you shouldn't consider the suspects in this case. Well, I'm here to tell you that the burden of proof here remains on this side of the table. You must find him not guilty unless they can prove to you beyond a reasonable doubt that he's the guy that went to these houses and started these fires. They've got to prove it to you. Our job isn't to prove one thing to you. And that's why the judge gives you an instruction that Mr. Ford didn't even have to testify. He doesn't have to testify because he has no burden of proof. He doesn't have to prove anything to you in this case. What we have to show you is, in like every case in the history of the United States, criminal case, is we have to show you there's reasonable doubt. I don't have all the answers. Mr. Riley doesn't have all the answers. These folks don't have all the answers. That's why there's reasonable doubt in this case. The suspects that we're going to talk about, and I'm going to touch on in closing argument, were created by the defense. They were created by the state of Ohio, by the Akron Police Department. They want to talk about following the evidence. We are simply following the evidence. I don't have to tell you it was this suspect. I don't have to tell you it was that suspect. I don't have to tell you who it was. You could theoretically think that they proven by something less than proof beyond a reasonable doubt that maybe it was even Stanley. And it's still a not guilty verdict. The reason we point these suspects out and we point out the lack of investigation as it relates to the rest of the suspects is because it creates doubt. Can I sit here and tell you it was one person and not the other? I cannot. That's what God's for. Someone's going to have to answer to God someday for what happened on that street in both 2016 and 2017. That's not our job. Our job is to be analytical. Our job is to take this as an academic exercise and to hold the state of Ohio to its burden of proof. To its burden of proof. And to do that, you have to look at the entire investigation. And I warned you, I said it's uncomfortable, but to look at the entire investigation, you have to be critical of it. You have to be critical of what the police did or did not do in this case. They've identified some suspects, they never followed up with them. We're going to talk about that. It's not because I don't like the police, it's because they didn't do their job here. I want you to think about this. In 2016, they had all of those suspects. And they had Stanley Ford as a suspect in 2016. And nobody got arrested. Nobody. Because they didn't think they had probable cause to even charge anybody. 2016, no one gets arrested. 2017 in January, there's a car fire. Nobody gets arrested. 2017 in May, there's a house fire. There is an incredible amount of pressure on the Akron Police Department to arrest somebody. Once they make that decision, they don't care about the other possible suspects. They don't look at the other possible suspects. They don't even focus on the other suspects. They don't even check their alibis, and we're going to talk about that. An incredible amount of pressure to arrest somebody. And the easiest guy is the guy that's living actually in the neighborhood. The one suspect that they have for sure that's living in the neighborhood. But think about what they haven't done in this case, please. If you consider what they haven't done in this case, and what they should have done in this case, once again, it doesn't make me happy to point that out, but it creates reasonable doubt. Now, I told you in voir dire about reasonable doubt, and I want to touch on this before we get to the other suspects and the lack of a police investigation here. I want to focus on that. I told you in voir dire that there are different levels of proof depending on the level or the kind of case we have in our justice system or our legal system. I talked to you about preponderance of the evidence, and I talked to you about if you're suing somebody for money damages, you have to prove by a little bit more than not, right? And I talked to you about clear and convincing evidence. And I told you in voir dire that the state of Ohio can theoretically prove by clear and convincing evidence that Stanley Ford was the guy, if you thought that. And you would still have to vote not guilty because clear and convincing evidence is a lesser burden of proof than proof beyond a reasonable doubt, which is our highest burden of proof. So even if you thought it was in that range, you still have to say not guilty, once again, because we're not all-powerful, we don't see, we don't have videotape, we're not eyewitnesses, and we're not God. So in the greatest country in the history of civilization, believe me, there's a lot of flaws in it. In the greatest country, the greatest legal system ever known to mankind, we don't make the defendant prove he didn't do it. We make them prove he did do it to take away his freedom, or to kill him potentially in this case. We make them prove it, and if they haven't proven it by that standard, we come back and say not guilty. That's what makes us a civilization, the best country in the world, a civilized society. We hold them to their burden of proof. So if they've proven it to you by preponderance of the evidence in your mind, it's not guilty. If they've proven it to you by clear and convincing evidence, it's not guilty. That's why it's important to criticize the investigation. That's why it's important to criticize the things that they did not do in this case. Proof beyond a reasonable doubt, the prosecutor put it up there. Proof of such nature and of such character that an ordinary person, folks, that's you or I, that's us, that we would be willing to rely and act upon that level of proof in deciding the most important of our own personal affairs in our lives. Think about that. Proof of such character that we would be willing to rely and act upon it in deciding the most important matters in our own lives. Now, the prosecutor will tell you, and they often do, well, we use that in traffic cases. Proof beyond reasonable doubt. It's not such a great level of burden of proof. We know, number one, it's higher than clear and convincing evidence. That sounds like an awful lot of proof, doesn't it? Number one. And number two, in a traffic case, you know what you have? You have a law enforcement officer often on the side of the road, eyes on the infraction that's being committed, with a videotape of the infractions being committed. And oh, by the way, he probably has a laser gun, scientific proof that the speeding or whatever it was being committed. That's proof beyond a reasonable doubt. It doesn't matter if it's a traffic case or a death penalty case, the burden of proof stays the same. But that's why it's not a lessening of the burden to think about that. And I bring it up because often, and I know this, we get to sit down and they get to stand up again and rebuttal and say things like that. Now, I don't know if Mr. LaPrenzi was going to say it or not, but I'm talking about it now because I can't stand back up and I can't tell you what my response to what he has to say is. And I want you to keep that in mind as we go through this process. Proof beyond a reasonable doubt. Let's, God forbid, one of us, has a loved one who's on life support in a coma. God forbid. And we have to decide whether or not we're going to crudely pull that plug. That could be one of the most important of our own personal affairs. I've just taken the definition. That's the definition of it. And if we have to make that decision, we probably want to know from 2 or 3 neurologists or neurosurgeons, whoever they might be, that they don't believe by medical evidence or scientific evidence that our loved one is ever going to come out of that coma. Because if they thought otherwise, we wouldn't pull that plug, would we? That might be one of the most important of our own personal affairs, and that's the level of convincing that we have to make that decision for our loved one. The law says that's the level of certainty you have to have that they have proven to you that he did these things to say guilty. It's the same thing. It's an example of it. Think about that level of proof in deciding this case. So, when I talk to you about the other suspects, I don't talk to you because I'm pointing the finger at one of them and saying, I know they did it. I don't know. That would be a lie. We don't know. But they have to be taken into consideration in the context of, have they proven their case beyond a reasonable doubt, or are there other legitimate possibilities in this case? Now, sometimes, and the judge will tell you, you have to take the evidence for what comes from that witness stand. And sometimes we don't have all the evidence that we want to have as jurors in making our decision, because sometimes the police department doesn't finish the job and give us the rest of the information. And because they haven't given us the rest of the information, that can create reasonable doubt in a case, because we don't have those answers. So let's talk about first the 2016 fire, if you will. Let's talk about Thomas Hughley and Ronald Garrett. Thomas Hughley and Ronald Garrett, we know, lived in the basement of 719 Bolts. Thomas Hughley, we only heard his statement because, unfortunately, he passed since of other causes, but we heard his written statement. Thomas Hughley, just because he's gone, folks, doesn't mean we can't be critical of him. Just because he's gone, he doesn't tell us the truth in that statement all the time. He was asked by me when I cross-examined him, when we read it in here, he was asked about the partying that goes on in that house. And he denied it. He said, nah, we didn't do that. That's not true. Those guys were drug addicts. They were transients. And I'm not putting them down, I'm telling you the facts of life. They were transients, they were drug addicts, and they lived in that basement. And how do we know that? We know that because you heard me question the detectives in this case about Gregory Lewis. Gregory Lewis was the brother of Lindell, who had also lived in that house a year prior. He got the heck out of there because he said Thomas Hughley and Ronald Garrett were pissing off their drug dealers because they were taking their drugs on consignment and they weren't paying for them after the fact. And that there was confrontations at 719 Bolts. That's what we learned. We not only learned that from him, but we learned that from the guy that installed the videos, Mr. Sibley, too. He said, I was a drug addict. I know that there were drug addicts and prostitution going on in that house. We heard from the neighbors, they called it a wild bunch. So Mr. Hughley, just because he's gone doesn't mean we have to believe everything he said in his statement. He didn't tell us the truth about what was happening there. And when he goes on to say that Joe McLemore had made up with Lindell Lewis, how can we hang our hat on that? The guy doesn't tell us the truth. He didn't tell the detectives the truth that day about his own drug addiction, about owning drug dealers. We can't trust that. Why is that important? It's important because after Tanisha Stewart learns from Gregory Lewis about what's actually happening at that house, she never goes back and interviews Thomas Hughley again. She never goes back and interviews Ronald Garrett again and asks them, who did you owe this money to? Who did you have these conflicts with at the house about the drugs that you owed? The physical confrontation, who was it with? If I'm an Akron police detective, I kind of want to know. I want to know who had motivation, motive. The prosecutor talks about motive. Let's talk about motive. Who had that motive? We don't know, you know why? Because they didn't do their job. They could have asked those drug dealers, they could have gotten those names, they could have saw where their whereabouts maybe were, they could have asked them for their alibi, and then tried to confirm it or deny it. They did none of that. Speaking of drug dealers, we have another one that Timothy Gary tells us about, and that's Anthony, the self-proclaimed biggest drug dealer in town, who lives on Russell. No one ever speaks to Anthony. Not once. Not once. Even though their witnesses are telling their detectives about these folks. Not once do they do that. Don't you want to know what those people would say? Don't you want to know where they would have been? Maybe. The Circle K guys. The prosecutor wants to say they got different clothes on. I look at that picture. I don't know if those were covers, overalls, or whatever it was that was put on the person that said 19 volts. We don't know whether they took those clothes off before they went into Circle K. We have no idea. And as the prosecutor rightfully points out, we don't know if there's a third person in that truck. We have no idea. Here's what Detective Looney told us, though. Detective Looney told us that we actually had a name of one of those guys that was in the truck. And I said, Detective Looney, what did you do to follow up? Well, I made a call. They wouldn't talk to me. Really? Stanley Ford didn't want to talk to him either, did he? What did he do? He drug Stanley Ford down to the police station. What did Detective Looney do with the Circle K guy? Absolutely nothing. Nothing. How about that guy's background? Maybe we should know about it. We do know that he deals drugs down the street, though. And we do know that his truck was driven throughout that neighborhood, throughout the attempts on the fire. And we don't even bother to make him talk to us. Let's just forget about that. That's not important. How about going to Circle K, and how about talking to the clerk who served those guys that night? And how about finding out what they bought? How about reviewing the video and seeing whether or not they were putting gas in a gas can? How about doing something like that? How about pulling the DVR at Circle K? We know, folks, that DVRs, even if they're not functioning, like this one from Linda Lewis's house, all burnt up, we know we can get days and days and days of video off this broken down, burned up DVR. That DVR at Circle K was never even considered. Don't we want to know who those people were that were at Circle K that were driving through that neighborhood over and over and over again that night, who were floating around that neighborhood, going in and out up East Avenue at the time of the commission of the fires? Isn't that reasonable doubt? Not even attempted. And he thought he had a name. He didn't even confirm whether the name was good or not. That's unacceptable in an aggravated murder death penalty case. Let's just put it on one guy. Ronald Garrett. Not only could his drug dealers have been bad, but we learned from Thomas Hughley something pretty important. We learned that Ronald Garrett, who lives in the house, for some reason, don't want to stay in the house that night. We learned from Thomas Hughley that he's cutting lawn. He's cutting a lawn over here, and he sees Ronald Garrett walking up 719 Fultz the evening before the fire starts. And then he goes, I don't see him again. He's gone. Ronald Garrett, folks, by Tanisha Stewart, is asked, where were you? He says, I was at my niece's house, and gives an address with an apartment number. It's a high-rise. And I asked Tanisha Stewart, did you talk to the niece to see if you could confirm that he actually stayed where he said he stayed the night of the fire? And she comes up with she sits here after we've heard from other officers. That's why I asked all the other officers, because I knew what she was going to do. And I talked about reports of investigation. And I talked about it being the Bible of what we do so we can go look back years later and we can be fair both to the state and the defense. And she says, well, not everything makes it into my ROI. Not everything. That's a bunch of garbage. That's a garbage. That's what she tells you, folks, because she knows she didn't do it. Maybe I sent someone else off to look or to talk. I don't have it in my ROI. You are the lead detective in this case. And you can't tell us whether someone talked to Ronald Garrett's niece to see if he was in that apartment that night? I asked her about the video. Did you do the video? And she goes, well, you wouldn't really believe if a relative said it, they'd be covering. I said, okay, fair enough. You're in an apartment complex, an old folks home, and you know there's video. She acknowledges that. Did someone watch the video? Well, I don't know. Maybe someone did. It's just not my notes. We cleared it. You cleared it? Where is it? Where is it in your investigation you did these things to confirm his alibi? What if she would have looked at the video or talked to the niece and the guy was never there that night? The guy who lives at 719 Fultz who never comes home that night. And they want to say, well, he had some of his belongings downstairs, so therefore he couldn't have been a suspect. Where are the answers to these questions? We don't have them because they didn't do their job. Because they didn't do their job, there's reasonable doubt. Ronald McLemore. We know from Thomas Hughley that Ronald McLemore actually confessed to starting this house on fire a year or so earlier, along with a van, because he was angry as hell with Lindell Lewis. So angry that he took Thomas Hughley's gasoline that he used to cut, the grass man used to cut the neighborhood, and set the van on fire and tried to set the side of the house on fire. And Thomas Hughley said that's why we have the new aluminum siding. Because that man tried to burn Lindell Lewis out. Because he thought Lindell Lewis stole $3,000 of his SSI money while Ronald McLemore sat in the Summit County Jail. And on top of that, mind-bogglingly, we also learned from the detectives and from other people, including Mr. Hughley, that McLemore also lived at another house owned by Lindell Lewis in the past, and what on South Street. I specifically asked about it. And what did we learn, McLemore, what happened to that house that McLemore lived in too, owned by Lindell Lewis? That it burned up. McLemore is around 2 arsons, both as they relate to Lindell Lewis, both of his properties. He lives in both of them, and they both burn up. What a coincidence that is. He's discounted as a suspect. They cleared him. Where was he that night? We checked at the Haven. He had been in the Haven for 3 or 4 days. Where was the re-interview of him? Where was the pressing of him like they pressed Mr. Ford over and over and over again, or where his whereabouts were? So we could check that out. Not done. Do I know that it's any of those 3 sets of drug dealers? No. Do I know that it's Ronald Garrett? No. Do I know that it's Mr. McLemore? Absolutely not. But my job isn't to prove to you who did it. My job is to show you that there's reasonable doubt as to whether they can prove he did it. Francine Lewis and William Pryor. Do I know they did it? I know. What I do know is that Tanisha Stewart labeled them as suspects in her report of investigation in 2016. Why did she do that? Well, she tells us when I show up on scene in the morning and I'm starting my investigation, Francine Lewis is there, and unprompted, in other words, she didn't ask her any questions. The first thing out of Francine Lewis's mouth is, I had nothing to do with this. She said she found that pretty suspicious. I had nothing to do with this. She digs a little further, and she finds that Francine Lewis has a life insurance policy on Lindell Lewis that he doesn't know about. She digs a little bit further, and she finds out that her boyfriend is William Pryor. And I asked this specific question. We had to go to sidebar, but she was allowed to answer. And I said, Miss Stewart, when you interviewed William Pryor, you talked to him about a prior death, not that he committed the death, but he lied to you about how it happened, didn't he? You knew that as you sat in the interview that he was giving you false information. She said, yes. I knew he was lying. Before I forget, I'm jumping around and I apologize, stay with me. Ronald Garrett. Not only did they not get the video or talk to the niece, do any of those things, not only did they not do that, but she says, I wrote these down, in her report of investigation, it was apparent that they were withholding names and information. He was from the she interviewed him. He gave inconsistent answers to my questions. He was very elusive and vague when I questioned him. And he lacked a forthrightness. She concludes, I'm suspicious of him. Those were the detective's words about Ronald Garrett. Back to Francine Lewis and William Pryor. In her ROI, she didn't want to tell us this. I had made her get it out while she was whistling and humming and singing for some reason. Don't know why that was. That was the oddest behavior I've ever seen from a detective from a witness stand in my entire career. But that's what she was doing, whistling, humming, and singing from the witness stand. A little nervous, maybe? I asked her about William Pryor, and she said, well, they weren't the same age. I said, no, that's not what I'm talking about, detective. You're not answering my question. I said, I asked you what is in your report of investigation when you compared the physical description of William Pryor to Stanley Ford. And she says, in her report of investigation, in the so-called Bible, same age, approximate age, same complexion, same facial hair, and same build. Those are her words in her report of investigation. We know that William Pryor and Francine Lewis and Gloria Hart don't like each other either. I said, all of those things made them a suspect. First she said no. I said, you wrote it in your report they were suspects. You can't back off of that now. You said it yourself. I want you to forget about that. I want you to forget about all those things and rush to convict Mr. Ford. Nobody got arrested once again in 2016. Nobody got arrested in January of 2017. Somebody was getting arrested in May of 2017 when that second house fire happened. Somebody was. Ronald Garrett, by the way, after the fire, they had to put out a be on the lookout for this guy. And they don't even get to talk to him for 4 days because he don't want to be interviewed. It's his house, they said it. It's his house, it's his belongings. Where the heck is he? They had to find him. Isn't that suspicious? Shouldn't he be back there if he's got these nice suits or whatever he says he's got in the basement, he wants them back? Someone burned down his house? Shouldn't he be there trying to help? Be on the lookout for him. They had to go find him. Why don't they go back after they talk to Greg Lewis and find out what's really happened at 719 Fultz and re-interview Hughley and Garrett? Why not? Nobody did. The only time anyone ever talked to Thomas Hughley was in the Akron Fire Department truck on the scene after he had to run out of a house and was under all kinds of stress. They never even went back and talked to this man. And he's in the indictment against Stanley Ford. Stanley's accused of attempted murder of him, and they took about 5 minutes to talk to him. What do we see in 2016? Tanisha Stewart, she identifies, I'm going to call it this, I'm going to leave it up to you folks to decide what it is that you're seeing. But we heard about infrared and the lights the colors aren't always the same, and I agree with that. The colors aren't always the same. So do we know the color of the pickup truck? Well, we know the one from Circle K. We know that one. And it's a pretty good bet that the one at Circle K is also the one that's going through that neighborhood because they have it leaving East Avenue, going down towards Circle K, and then a minute or two later, they get down the street and they're at Circle K. So it's a pretty good bet that the truck that we see in the neighborhood is, in fact, the truck that's at Circle K. She talks about it has a white stripe on the bottom of it. Remember she was saying that? White stripe, white stripe, white stripe. That's what we heard over and over and over again. White stripe. Maybe it is a white stripe, and maybe she's right. I don't even know. But we see in that neighborhood a truck that it probably is, the truck that's at Circle K. We also see after the second attempt on the fire, we see another truck. Now, could it be the same truck? It could, because here's what we know. We know I don't know how to do that. Here's what we know. I've been waiting all trial to utilize this thing. This is my technology. So we know that East Avenue is up here and runs down here. We know that. There's East Avenue. We know that's Stan's house. We know that's Stan's mother's house. We know 719 Fultz is up here. We know 693 Fultz is up in this area. Russell, where the truck fire is. We know you can take, we've asked people to testify to this, you can take Russell Avenue to East Avenue and get out of this neighborhood by going down Russell. You can also come into this neighborhood by going down Russell, coming down this way and coming around this way, or coming up Hillcrest. We know that. So there's different avenues to get in and out. What we do know too is that we only have video down in this area from 714 Fultz, 2016 from 719 Fultz. We know that's where the videos are coming from. And they're facing this way. So we don't really know if somebody comes in the neighborhood, by those videos anyway, we don't know if they came around this way. We don't know which way they came. We do know that down East Avenue down here would be Circle K. We don't know how they get in and out of the neighborhood, at what time do they actually get back to the neighborhood, unless we see from the video that they actually came in off East Avenue down Fultz. Then we can pick them up coming in and going. Other than that, we don't know. But what we do see on the video, is it the same truck? Is it not? Are they the same suspects as the drug dealers that live down here? The guys that we see in the truck? We don't know. But we do see a truck come down from this area, down Fultz, and turn around here and go back. Same truck or not? I don't know. But it looks like the person that's doing that is pulling up to here, and they're checking out to see whether or not 719 Fultz actually caught fire or not. That's what it looks like. And then turning around, and they figure out it didn't. And then after that, we get the third attempt on the house. The third attempt. That truck is suspicious as well. Could it be the same one? It could. Could it have different occupants in it? It could. Could those people in that truck that turned around be different than the ones? The drug dealer, if he is the drug boys, is what the prosecutor put up there. Could it be different? It could. Could it be the same? It could. We don't know. We don't know. But Tanisha Stewart talks about these videos. And she concludes, and I went to her report, and she concludes in her reports that once the first and second fire was started, we had she says truck, now she says vehicle. But she says truck, and I pressed her on it, and she goes, well, I can tell by the height of the suspension. I want you to watch those videos. You can't tell. I don't care who you are. You can't tell coming off of East Avenue, that truck that stops here, vehicle that stops here, or car that stops here, turns off their lights, by the way. Turns off their lights, and you see, she puts this in her report, the person that starts the fire run back towards that truck turns around and goes back down East Avenue. She puts that in her report. Watch the video. You can't see, though, and I don't know why she's got to make it up when she gets on the stand, that that's a truck. She wants to talk about the suspension size or how high the suspension is off the ground. She's going to tell us that's a truck. Why? Why did she do that? Is it because later on she wants to implicate Stanley O. Mitchell? Because he is a truck too? I don't know. I don't know why she's got to make it up. I don't know why she makes it up in her report. It doesn't make any sense. She also talks about a pathway that goes from this street past 1374, and it's an alleyway she describes, and I told her to show it to us, and she puts this, or tells us that there's a pathway that goes here, and you can actually go up, it's an old pathway, up into East Avenue. And she tells us after the third attempt, the successful attempt, that she believes that the car that was involved that helped the guy get away the first 2 times up in this area, that turned their lights off, that she believes that that car is actually in this alleyway at the time, and then the person comes down from the alleyway this way to start the fire and runs behind the house. That's what she tells us. Now she wants to say, in 2017, well, upon further review, forget about all that stuff. Forget about all that. Let's just focus on this guy right here. A year later. That's what she tells us. The videos that we have from 2016 fire, I want you to keep this in mind. We have one snapshot in time, the 1 hour around which time this fire was set. Because when they go to 714 Volts, Chester Williams' house, on that day, they don't take the DVR. They put a little flash drive in and they only collect an hour's worth of time. It'd be nice to know what was happening in that neighborhood in the hours preceding that fire, wouldn't it? Might even be nice to know what happened in that neighborhood in the hours after that fire, even after the fire trucks left. But they didn't get that DVR at that time. They didn't do that until 2017. Why not? How about the DVR at 7:30 Volts? And when this car pulls down the street, folks, it stops before it gets to 7:30. Like the car coming down the street that turns its lights off and turns around and flees with the person who's starting the fire, like that person, maybe he knew there was video on that house. It's unplugged. That's all we know. Where's that DVR? If they can pull video off of this at the state chief fire marshal's office in Columbus, they can certainly pull it off a DVR if a camera's been unplugged. And who unplugged it? We don't know. What was on that DVR before it was unplugged? We don't know. We do know it was pointing right across the street towards 719 Volts. It'd be nice to know that. It'd be nice to have that information, but Tanisha Stewart makes the decision not to even bother. She says, oh, when a citizen tells us that, we just trust them. That's what she said. That's ludicrous. This is an aggravated murder investigation. We just trusted it. That's a poor, poor investigation in 2016. Stanley O. Mitchell. They brought him up a little bit. I brought him up. Can I sit here and tell you Stanley O. Mitchell was involved in this case? They said, well, he doesn't have any motive. We don't know, first of all, what conversations he may have had with Mr. Ford. And Mr. Ford told him, I don't like people at 719 Pulse. We don't know that. It's not part of the evidence. Motive is not important. That's not the deciding factor here. Stanley O. Mitchell, here's what we know about him on that night. And they don't interview him for 14 months after the fact. 14 months. We learned that Stanley O. Mitchell is out of his house around the times of the fires, and we know that because he told the police that night, I had to go to work at McDonald's. I asked Detective Looney, I said, that's about 6 to 8 minutes at best, hopping on East Avenue and going up to 76. That's 6 to 8 minutes away. And we know he clocks in at 4:02. Detective Looney told us that. They went and talked to him 14 months later as a potential suspect. 14 months. And they pull his records and they find out that he's there. What else does Detective Looney tell us? Detective Looney tells us that Stanley O. Mitchell most likely had access to 1370 and 1374 Hillcrest. That's what he told us. I don't know if Stanley O. Mitchell was involved in this case, just like I don't know if the rest of the suspects were involved in this case. And then they want to say, well, if he was involved, he was Stanley's accomplice, Stanley Ford's accomplice. How do we know that? How do we know he couldn't possibly be involved in this case and have a different accomplice? How do we know he wasn't the guy that turned off the lights here and turned around after whoever he was with ran towards him? They want you to conclude it has to be Stanley Ford. They don't have any proof of that. They just want you to conclude it. If he's got access to 1374 and 1370, he's got the key card, whatever it is, the code, he could have done it. It's possible. That's possible. Here's what's important. That key card, when they came in on alarm.com, I wanted to point out a few things. One of the things I wanted to point out, they just put the 3 dates up of the fires and say, well, it was disarmed. I want you to go back and I want you to look at all the months they had. There were many times over those months in the early morning hours where that alarm was deactivated. Many times in the early morning hours. That's why I asked in the painstakingly, it was boring as heck probably to everybody, but I was asking, didn't you, on this date, at this time, didn't you see disarmed by Stanley Ford, disarmed by Stanley Ford, disarmed by Stanley Ford? Yes, yes, yes. It wasn't just those 3 nights in question. And on top of that, 5 or 6 months, you'll have the records, you'll see for yourself in 2017, they did from, I think it was July 1st of 2016 until January of 2017, they didn't even pull the records. We don't know how many times it was disarmed in the early morning hours of those months between the 2 house fires, because they didn't even give the records to us. We don't know. The other thing about that, folks, is this. Detective Looney got on the stand and said, yeah, when Stanley got arrested, keep this in mind, the testimony is Stanley gets arrested May 23rd, 2017. Shortly after he gets arrested, Detective Looney testifies, yeah, he called and told someone to set the alarm. Well, he did. He called and told someone to set the alarm. That tells us a couple different things. I think he said he called his son, set the alarm. Tells us his son has the code, number 1, to set the alarm. And it was deactivated on May 24th, the day after he was in the jail. And then, even more importantly, over a month later, on June 28th, and you have these records, the alarm was disarmed again on June 28th of 2017 by Stanley Ford, if you look at the records. Now, we know physically Stanley Ford couldn't possibly have disarmed the alarm on June 28th of 2017 because he has been sitting in the Summit County Jail since May 23rd of 2017. Impossible. Impossible. So somebody else has that code. And that's not for me to sit here, folks, and tell you that Stanley Ford wasn't out of his house on 2016 or 2017 on the night of these fires. I'm not sitting here telling you that. They're telling you it's absolute proof that he started these fires and he's outside those houses. And I'm telling you it's not. That's not proof. He doesn't have to prove anything. He doesn't have to prove he was home sleeping. He doesn't have to prove one thing. They have to prove that he started the fires. He could have went outside. He could have done what the detective over and over, we're going to talk about this, suggested to him that he went down the street to get a look. And he still doesn't mean he set the fires. Just because the alarms go off, and even if it was Stanley Ford, that's not proof that he committed the fire. That's certainly not proof beyond a reasonable doubt. That's not proof of such character that you would rely and act upon it in the most important of your own personal affairs. That's what their whole case is. I told you in the beginning of this case, I promised you a couple things. I promised you, number one, we would never contest there was arsons. I told you we would never contest the cause or manner of death. And I promised you that this was going to be a whodunit, an academic exercise, that nobody was going to come in here and tell you this wasn't arson, this was an accident, this was an electrical fire, this was a grill that got out of line. None of that. I told you those things, and it's come true. This is a whodunit, it's an academic exercise holding the state to its burden of proof. There is no fingerprint evidence that links Stanley Ford to any of these crimes. Not at either house, not on the gas cap on the January of 2017 case, the truck fire. There is no DNA evidence that links Stanley Ford to any of these matters. There's no eyewitness identification that links Stanley to any of these matters. And outside of, and we're going to talk about these shoes over here, outside of those shoes, there is no forensic evidence that links Stanley Ford to any of these fires. And those shoes don't directly link them either. We heard about this alcohol, or this gas accelerant smelling dog. That's what we heard. And this dog got involved on 2 occasions. He got involved with Mr. Boggs. We're going to talk about him more. But he got involved with Mr. Boggs when they realized that he had tried to start his ex-wife on fire in the past. So he became a suspect right away, immediately. This is what he had done to her. Poured gasoline or kerosene all over her and tried to light her up. And he'd spent a lot of time in prison. He had just recently got out of prison, and now she's burned up. So he becomes a suspect. They go to his house, and they bring him to the Akron Police Department, and they run that dog by him. And they say that that dog alerts on things. And then they said, well, that's just a presumptive test. And then that dog, then we sent it off to the lab and we confirm or not. And we brought the scientists in to confirm or not, right? That dog hits on where? Hits on that man's socks, that's what they say, right? Walks up to him, sniffs him, and hits on his socks, they say. They never, ever, even though it hit on the socks, they never confiscated Mr. Boggs' shoes. They never had his shoes tested. That dog is hitting right down there. Never got his shoes, never tested his shoes. Just Mr. Ford's shoes. And what they tell you is that we went to do the search warrant in this house. That's when they pulled Stanley out and they put him on the street with Detective Looney, and that's the May 18th, second biggest interview, I guess. And as we do that, we bring that drug dog in there, or gasoline dog in there, and that dog hits on several things, and we take, and you have the exhibits, his hoodies, his Carhartts, whatever they have that looks like that video from across the way, in 2016, they take all that stuff. And it all comes back negative. The only positive that we have are these shoes. And these shoes, and they showed you some pictures of them, and you'll have them as exhibits. These shoes are pulled out of a trash can, I believe from 1370 volts, and that back little, behind that side door, there's a trash can there. And what do? They dump out that trash can. And they see these shoes through that trash can. And they test those shoes, and there's some a positive result. What's in the trash can with the shoes? A bunch of trash. What's on the items that are in the trash? Was there gasoline or some kind of accelerant on those items in the trash that were mixed in with the shoes? They don't test anything else in that trash can, just what's in the shoes. Just the shoes. How do we know that some other item in that trash didn't have an accelerant on it, and now it's on his shoes? We don't know. They didn't test it. They didn't do those things. I want you to look at those shoes. Those shoes are beat up, right? There's some grass, some dry grass in them. I don't care if he used those shoes to cut the lawn. I don't care if he used those shoes, as they said, and you'll hear in the tapes, to work on the cars in the driveway. Those shoes are old and they're beaten up, and there's some, if you spread the rubber out, there's some slices in the bottom of the soles. So they're all beaten up. Here's what's really interesting. This happens in May of 2017 when they take those shoes out of that house. What's really interesting is those shoes that were placed in the trash have no shoelaces in them. Why don't you just take a look at the condition of them? There's no shoelaces. A man who they claim runs from 693 Fultz from 693 Fultz down Fultz and into this area. They claim it's Stanley. They say he did it, I think, 3 times. No shoelaces? Who takes the shoelaces out of their shoes if they're trying to cover up an arson? I mean, the shoes get gasoline on them, but the shoelaces don't, so we shave the shoelaces? Does that make any sense? That you would pull the shoelaces out? Does it make any sense you would run down the street to start this fire with shoes that had no shoelaces? The shoes are going to fall off his feet. That makes 0 sense. But that's what's in the trash can, along with whatever else is in the trash can that was never tested. The keypad, I asked Detective Looney, anyone check the keypad at 1374 Hillcrest shortly after the 2016 fire, or shortly after the 2017 truck fire, or shortly after the 2000 and, I said 16, I meant 17 the first time, 17 house fire. Did anyone at any point in time check that pad for fingerprints or DNA? And I said to him, I said, you know what? If my fingerprint or DNA was on my kitchen countertop, that wouldn't surprise you, right? It wouldn't surprise you because it's my kitchen countertop. But if somebody was in my house and their fingerprint was on my kitchen countertop and they had no business being in my house, that might be indicative of somebody who we want to have as a suspect. So I'm not saying check those fingerprints to see if Stanley Ford's are there. He's in and out of there all the time. I'm saying, did you check the fingerprints or the DNA on that keypad shortly after any one of those 3 fires to see whether or not somebody's DNA or fingerprints were there that shouldn't have been there? Might be somebody we want to talk to. And I asked him, I said, you know, there are bad people in this state, and when they have a bad person in the state, the police department keeps a bank of information where we know known felons' fingerprints and DNA, and we can compare it to crime scenes when we find unknown fingerprints and DNA to see if there's a match. Did we do any of that in this case? Absolutely not. Same thing for that door at 1370. Did we check DNA or fingerprints at the door at 1370 that is supposedly creaking open on the side? Absolutely not. None of that is done. How about the DVR, by the way? I'm going to force the 2017 fire of the guy who's right here. I asked him about that. We couldn't pronounce his name. That was really late in the testimony of this trial. Did we ever pull that DVR? No. How about on East Avenue up here? How about on East Avenue? Because we learned that Stanley O. Mitchell lives right down here on East Avenue, right off of it. There's a Catholic Charities there with a video. Did we pull that DVR to see what was on that DVR? No. Didn't do that either. Andrew Buxco. That's the guy that lived over here with his camera pointed straight at 693 volts. Never saw that video. Never even tried to see that video. Let's talk about the 2017 fire. May of 2017. I want to focus on two people that are interviewed by Detective Looney in May of 2017. First of all, I want to talk about Miss Beverly Ewing. I asked Miss Beverly Ewing specifically, when you were interviewed, actually I think it was Weitzel that interviewed her, but he's the lead detective, so he's aware of the information. When you were interviewed, you were asked about suspicious people in the neighborhood who could have done this. She said yes. I said, what did you tell them? And she said, in the days and a month or so preceding the 2017 house fire, almost every night there was a suspicious black vehicle that pulled up on Hillcrest, about here, parked between 9 and 10 p.m. at night, almost every night. And the person never got out of the car. Until, she said, the morning after the fire. What does she tell us about the morning after the fire? First of all, she tells us, to recreate the scene, she tells us that there are fire trucks and police everywhere. There is a burnt up house at 693 volts. And anybody who has any sense about that whatsoever, who is in the neighborhood on the daylight hours of that morning, would know that there was an enormous house fire. That's what she tells us. And she says, this suspicious car that pulled up for an hour at a time from 9 to 10 most nights and parked there with nobody getting out, for the first time ever, the neighbors are out and about, people are talking in the neighborhood, this person gets out of the vehicle. And she says this person has a big smile on his face, which she finds to be very suspicious. And he makes the comment, what, did somebody get shot? And then he says, well, that's just black on black crime. He's a black man, by the way. That's what she says. That's just black on black crime. With a big smile on his face, and she finds him to be very suspicious. She says he then gets back in his car, and I specifically asked her, did he ever, after that morning, ever come back into that neighborhood to your knowledge? Did you ever see him again? And she says no. So the police are aware of that in May of 2017. They interview Stanley Ford, either on the 17th or 18th. It was on the tape and we heard it. And they're asking Stanley about the neighborhood that night, that day. And Stanley Ford tells them, I called the police, tells Detective Looney that, I called the police. There was a suspicious black vehicle right here that drove up with its lights off, and parked right there. And I called the police. There's an exhibit, folks, that you're going to get. And then when I asked Detective Looney about it, he goes, it says anonymous. We don't know who called him. I said, the caller information is from 1374 Hillcrest. And he goes, well, we don't know if that's Stanley. I said, Detective, you interviewed Stanley Ford. He didn't want to give this up, of course. You interviewed Stanley Ford, and he told you about this vehicle prior to the nights of fire. He told you that he saw this, and he had called the police. And I said, using your powers of deduction, Detective, and your experience as a detective, the fact that it comes from 1374 Hillcrest and Stanley Ford before he saw the report told you about it, we can conclude Stanley Ford called the police and talked about the suspicious vehicle in the neighborhood. And he said yes. I want you to pay attention to that defense exhibit. That happened, folks, on April 13th of 2017, about 1 month prior to this fire. 1 month prior, Stanley Ford is calling the police about a suspicious vehicle in the neighborhood and describing it. And he gives the detective, or it's on the police report, provides the license plate number of the vehicle to the Akron Police Department. I asked Detective Looney, I said, Detective, this exhibit that I've given you, your office, your department provided this to us in discovery. That's when we get the evidence. They have that evidence. I asked him, did anybody check to see who owns that car? Never once. They don't even know to this day. Wouldn't it be nice to know who the owner of that vehicle was and question them about what they were doing? Wouldn't it be nice? That's outrageous. And guess what? Guess what? Stanley Ford's story, the fact that he called the police, and the fact that there really was a suspicious vehicle in that neighborhood, you don't even have to take Stanley's word for it. He didn't make it up. Beverly Ewing told the police the same darn thing. And guess what the time of that was that the call was made by Stanley Ford? 21:42 hours. 21:42 hours. That's 9:42 at night. It completely corroborates with what Mrs. Ewing said, Beverly Ewing. She said between 9 and 10 every night. He calls at 21:42 hours and talks about that. And we have no idea as we sit here, 9 people dead. We have no idea who the owner of that car is. That's outrageous. You want to talk about suspect? You want to talk about reasonable doubt? Let's just forget about that. In May of 2017, let's forget about all that. Let's get somebody because we're under extreme pressure to charge. Because we've had 3 fires in this case. In that neighborhood. Let's forget about all that. Well, guess what, folks? Today's the day of reckoning. We can't forget about that stuff. We cannot forget about the reasonable doubt in this case. Follow the evidence. That's evidence. You don't have those answers. They didn't provide them to you. They didn't do their job. Please take the time to look at that report. It's critical. Do I know that the person, the suspicious vehicle that was sitting there, is the person that started that fire? Absolutely not. I don't know. I'm not God. But I know it should have been looked into. I know we should have crossed our T's and dotted our I's before we charge somebody with these heinous crimes. Patrick Boggs. Let's talk about Patrick Boggs. Talked about him a little bit. I'll try not to repeat. Patrick Boggs, when he's picked up, he's brought to the Portage County Jail. And there's an exhibit from the Akron Beacon Journal of May 17th of 2021. He's in the jail. And you heard, and Detective Looney said, we learned that the Akron Beacon Journal is provided to in the cell block or the pod, so if you want to read the Akron Beacon Journal, it's there for you. First of all, I'll tell you that there is not one shred of evidence in this case that this Mr. Selby, who says Boggs confessed to him, there's not one shred of evidence that he actually read the Akron Beacon Journal. Okay? They want you to assume he did, right? But here's a fact. You're going to see that article, and you're going to recall my questioning of Detective Looney. First of all, I said, Detective Looney, you know in 2001, because you got the file from when he's trying to set Angela Boggs on fire, you know that was racially motivated and made him a suspect in this case, Mr. Boggs. And he said yes. He thought, Mr. Boggs back then, that she was having an affair with a black man. Mr. Boggs is a racist, and he said yes. Mr. Mr. Boggs is a racist. Boggs didn't like that, so he tried to set his wife on fire. He goes and does his prison term, and what do we know now? Angela Boggs has children now with a black man. We know Boggs doesn't like that. And here's what we also know. We know, even if you want to assume, and that's an assumption, it's not a fact, that Selby, the inmate, read the Beacon Journal. We know from reading the Beacon Journal article from the 17th of May, by the way, this conversation with Boggs takes place on the 21st of May, 4 days later. We know that nowhere in that Akron Beacon Journal article does it talk about the racial motivation for Mr. Boggs to go and try and burn down 693 volts. Doesn't say it in there. So how would Selby, if it wasn't in the Akron Beacon Journal article, he was making it up as the prosecutor wants you to think, how would Selby know about the racial motivation of Boggs to go after Angela Boggs because she was living with a black man, unless Boggs himself told him that? What do we know? We know from the deputies that came through Detective Looney, we know the deputies in the Portage County Jail on the 21st of May of 2017 witnessed Boggs out of his cell and Selby out of his cell, and they were conversing throughout the day. So we know they talked. We know when Selby pressed that intercom to come talk to the deputy, Boggs was in his cell right next door, and Selby didn't want to talk. He was scared. He motioned towards Boggs' cell and said, I want to talk to you, but not here. Bring me down the hall. I don't want to talk out loud. Bring me down the hall. And we know in that police report that was furnished by the Portage County Sheriff to Detective Looney's office, we know that as he got down the hall, he was shaken. That's what's in the report, that Selby was shaken by this. And he said, that guy killed the family in Akron. He confessed to me. I can't believe he did it. He actually killed one of his own children. Now, if you read the Beacon Journal article, there is a Boggs listed as one of the deceased, one of the older child. I get that. But nowhere in that article does it speak to the fact that it was racially motivated. On top of that, folks, I want you to remember this about Boggs. I asked Detective Looney specifically about this. I said, Detective Looney, you interviewed some people that were family members to the people that perished in that fire. I said, namely, Brittany Boggs, the daughter who was off at Cedar Point, remember that? And you interviewed Ty Huggins, the son of Dennis Huggins, who lived in Indiana at the time. Dennis Huggins had kicked him out of the house about 3 weeks earlier. And he said yes. And I said, what you learned from those two folks was that Patrick Boggs was actually on Fulton Street dropping Brittany Boggs off. Brittany Boggs told you that, and Ty Huggins witnessed it on at least 2 occasions outside of 693 Fulton. And when you, that's important, because when you interviewed Mr. Boggs, detective, you know he lied to you. He lied to you because you asked him if he had ever been over there before, and he denied ever being on that street. Detective Looney said, yes, I knew he was lying. Why does Boggs lie about that? He had been over there. He did know where that location was. He knew where Angela Boggs was. And he's a racist, and he can't stand the fact that she's with Mr. Huggins. Isn't that important? We talk about the porch and the charcoal, right? And it's in the article, it was done with charcoal. Read that article. It talks about charcoal, but it also talks about going in a trash bag or something like that with charcoal. No one's saying the fire started on the porch. Couldn't there have been charcoal on the porch that was used in that part at that party? And couldn't some of that have been put in that trash can that Bill burnt down to the ground to help start that fire with an accelerant? Couldn't they have taken some of the partially used charcoal, put it in the trash can, pour gasoline on it, poof, and the can goes down to nothing as they showed you in the picture. Nothing. Couldn't that be accurate? Couldn't that have been what Bob's told him? I don't know because I wasn't there. But I know Mr. Selby has information that is not in that article, and I know there's no proof that he ever even read the article. They want to say that he couldn't have done it because his cell phone wasn't there. First of all, I heard testimony about 3 cell phones that were connected to his name. Only one of which they had cell phone towers hitting off of in Ravenna for. The other one, Tracy Evans, is Boggs' sister, and we heard that he had one of Tracy Evans' phones too. But we also heard that the information about where those phones were and what calls they made stopped on 2 of those phones on May 11th. The fire happened on May 15th. Those cell phones are useless to us. They don't confirm where he is. The fact that his car or truck is at the scene or at his apartment doesn't mean he didn't go to Akron and do these things. I wouldn't want to take my truck on scene either if I was going to do what he did, potentially, right? Once again, I don't know if he did it or not, but he's a suspect. I wouldn't want to take my phone either. I don't think you have to be a rocket scientist to do those things. That means nothing. That doesn't eliminate him as a suspect. It does if you have a lot of pressure on you to find somebody and arrest them. I don't know Dennis Huggins, never met him. But I do know he was a drug dealer. He sold weed. I know that because it came out in the testimony presented by the state. I know that there was an argument at his house the night before, or the day of, excuse me. And I know from Tiffany Gary, and I'll use her words, there were a lot of dudes in and out of that place. I do know that about it. Do I know if any of those people had anything to do with this? Absolutely not. But I do know that those are facts in this case. Interestingly, when you compare 2016 to 2017 in the fires, interestingly, don't know if it means anything, but before the start of the second attempt at 2016, we see a vehicle come down, turn, and stop. And what do we hear from Tanisha Stewart? In the video shows the lights go out. That's kind of interesting because in 2017, what do we hear from Stanley Ford when he calls the police about the suspicious vehicle in the neighborhood? The car's driving without the lights on. Kind of interesting. Let's talk about Stanley's statements. First of all, I want you to keep in mind, May of 2017, May 23rd, 2017, they bring him to the police station. That interview, folks, by their own account, he was in that interview room for well over 3 hours. He was interviewed for well over 2 hours. But they're only playing 15 minutes of that interview for you. They're not playing the whole interview. You don't get to hear that. You've got 15 minutes of it. They talk to him on May 17th, they talk to him on May 18th. They bring him out on May 18th, and they put him in a car, and they interview him in the car, and talk to him. I think that's an hour and a half long. And then the interview, and I want you to be fooled again, on May 23rd, is not that 15 minutes. It's well over 2 hours of interview, and you don't get to know. Objection.
Sustained. The jury will disregard. Also, closing arguments are not evidence and shall not be considered by you during your deliberation.
Detective Looney told you from the stand that that interview was over 2 hours long. You're going to hear 15 minutes of it. What do we know about Detective Looney? We know he's gone through the police academy. We know he's a detective in the Akron Police Department, and we know he got training as a detective in the Akron Police Department. We know is he said so from the stand that he was familiar with interviewing, interrogating techniques. And oh, by the way, yeah, I guess I had a course on the Reed technique that I was talking about. We know all that. We know he's got a bachelor's degree. We know he's got a master's degree. We know he's got a doctorate. I said, you're an educated man. Clearly he is. Very educated. Very well versed. He knows how to interview people. The prosecutor got up after I talked about the Reed technique and he said, the Supreme Court says it's okay for you to lie to these folks. He says it's okay for you to not give them all the information. Right? That's what he said. Technically, we said, yeah. I don't have to tell them the truth. It's part of the interviewing process. The Supreme Court said it's okay. That doesn't mean, folks, you cannot weigh that evidence for what it's worth and consider who Detective Looney and Detective Johnny Bell are compared to who Stanley Ford is sitting in that car and sitting in that interview room and where he is. And I ask you to listen to his responses, the language he uses compared to what they do. And I'm going to tell you that he is no match for him intellectually. And I think that's apparent. Not only is it not a match intellectually for him, there's no hitting somebody over the head with a phone book or anything like that, but there is browbeating, mental browbeating that goes on in these interrogations. And they use the Reed technique to do it. And they try and wear people down and they mislead people and they don't tell them the truth about what's going on in hopes, folks, that they're going to confess. This is an intelligent jury. There are false confessions in this world. Objection.
Sustained. There was no confession, and we're not going to talk about false confessions. You'll disregard Mr. Gorman's statement and remember that closing arguments are not evidence and shall not be considered by you during your deliberations.
And I'm not telling you Stanley Ford confesses he didn't. I'm asking you to look at the psychological manipulation that took place in those interviews and that mental beatdown of him to try and get him down this street. That happened, and it happened the entire time it was going on. First they befriend him, they're nice to him. They tell him how much they respect him. They tell him all those things throughout the process. They tell him, when he won't tell him he was down the street, we see you going down the street. They don't show him the video. Because you know why they don't show him the video? Because they know they don't see him going down the street. Objection. It's argument.
All right, it is argument, and the jury will rely on its collective memories as to what the evidence shows or does not show, and that is totally your purview as the trier of fact. So again, remember that closing arguments are not evidence and should not be considered by you during your deliberations.
They tell him that. I'm not making it up. It's on the tape. We see you going down the street. We see you. If it was so strong, folks, they wouldn't need to browbeat him for hours to try and get him to say he was down the street. If this evidence is so strong. What do? They take him out of his house, in front of his family, they put him in a cruiser, they drive him down to downtown, they bring him up on the 6th floor of the Detective Bureau, in handcuffs. They tell him he's being charged with all of these aggravated murders. They've already decided. If you've already decided, why we got to talk to Stanley? But they tell him that. They handcuff him to a table so he can't move, and they leave him in the room for a while. And I asked Detective Looney, that's an interrogation technique. No. No, we're just getting our stories straight here. We're getting our questioning in line before we go in there. You can believe that if you want to. But they let him sit in that room, chained to that table, told he's charged with aggravated murder, and then they come in. And then the Reed technique takes over. We already know you did it. That's what they're telling them. We just want to know why. Why is that an element of this crime, folks? Why is not an element of this crime? We just want to know why. Maybe, Stanley, you went down just to take a look. Maybe, Stanley, you went down there, it was an accident. Maybe, Stanley, you just wanted them out of the house, you set the fire and it got out of control. Stanley, 7 people are dead in that fire. Children, Stanley, I got to go back and I got to answer to the family, Stanley. Help me out, Stanley. Help me out. Over and over and over and over again. And you get 15 minutes of it. That's what you get. Over and over. Stanley says, man, the timeline ain't adding up. I'm paraphrasing now, you'll listen to it. The timeline ain't adding up. It ain't adding up. I didn't do that, man. Johnny Bell, I didn't do that. I didn't do that over and over and over again. As they continuously, psychologically beat him down to get him down the street. Think about yourself. Put yourself in that position. You're already charged with aggravated murder. They already believe you did it. They're here intellectually, you're here. They've already decided to arrest you. They're telling you they're watching you walk down the street on video, but they won't show it to you. You're in that room trying to placate those gentlemen. You're trying not to make them mad because they got the charging decision in their hands. And they're telling you they're down the street. You scramble. You're scrambling for answers as you sit in that room. You're trying not to upset the detectives who are very upset already. How much worse can this get? Maybe I should say I went down the street. But I didn't do anything. I didn't do anything. I didn't do this. That's not the right timeline. That's what we hear in this case. That's what you hear. The day before, they bring him in the car. And they purposely put him in the car, and they have him watch all these different law enforcement agencies out there searching his house. And they tell him, we get it right. We get it right. We got to get it right. They interview him out there, and the same stuff happens. Not to the level you're seeing on 2023, but, or May 23rd, but the same stuff is going on. The techniques being employed. Psychological manipulation is being employed. And you have to ask yourself, it's so important. Again, I'll say it again. If it was such an open and shut case, because we got it on video, the grainy figure on video, the door cracking, and we've got an alarm system, and in the alarm system we got it being deactivated, and it says Stanley Ford. If it's such a great case, why do they got to get him to confess? Why are they pressing him so hard? It doesn't make sense. If that's enough evidence, why do we got to go there? Why do we got to keep doing it? Why do we got to tell him we need to know why? Why do we got to give him all these outs so he goes down the street in his statement? Sit down. I can't get up and answer whatever he's going to say. You folks have listened to this evidence, paid attention in this case. I'm going to ask you to take the law the judge provides you, not the law that we believe is, the law the judge provides you. I'm going to ask you to embrace, because that's what the law calls us to do, the reasonable doubt definition. I want you to recall how high of a burden that is, no matter what they say. Proof of such character that an ordinary person would be willing to rely and act upon it in deciding the most important of their own affairs. You know, sometimes, you know, prosecutors, when they have like Mr. Hughley as witnesses, and you know, and God rest his soul, sometimes, you know, they have people that aren't the greatest people in the world, Mr. McElmore and everything, and they talk about their witnesses, and you know, they say things like, well, if crime happens in hell, you're not going to have angels for witnesses. Sometimes they say those things, right? Because what they're saying basically is that they haven't said that in this case, but sometimes people want you to not focus on the credibility and assessing the credibility of people, which you have to do, no matter where they come from, no matter what their backgrounds are. You have to assess their credibility. You can't ignore their credibility because they come from a place that you don't like. So don't be fooled by any of that. What happened in this case, folks, is absolutely horrific. It's horrific what happened to two families in this case. Horrific. It can't be undone. Everybody's heart goes out to the families in this case. That's not why we're here. We're here to give Mr. Ford a fair trial and to hold the state of Ohio, because that's what civilized societies do, to its burden of proof. I don't get to decide whether he did this or they proved it. The judge doesn't, prosecutors don't, Detective Looney doesn't either. It's the greatest system in the world when we ask people to come in here and spend a month of their time as jurors. Outside of serving in the military, it's the greatest honor, the best commitment, the biggest commitment we can have to give back to this country, this flawed country that is constantly recreating itself and hopefully becoming better. But it doesn't work unless we get a cross-section of this community, which we have. People from different backgrounds, people from different genders, people from different races and probably religions, come in here, right, and sacrifice on such a horrible case their time and pay attention like you folks have paid attention in this case. Take my hat off to you for the job you're doing and you're going to continue to do. I ask you to do justice. I ask you to look at this case in an academic exercise and not let the emotion of it get in the way of rendering a just verdict. A just verdict. That verdict, folks, in this case, as hard as it can be, because we want someone to be held accountable for what happened in that neighborhood over a 13-month period of time. I get that. But that verdict, folks, is not guilty. We talked about the difference between not guilty and innocent, because I sit here today, I can't tell you what happened. I wasn't there. Neither were you folks. Neither were the police. It's not guilty. They haven't met that high verdict. And I quote, I don't think Stanley could do this to that family. And that quote, folks, came not from our witness, from theirs. It came from Audrey Taylor, who came in from Pennsylvania on that video. She said, I asked her, I said, what did you prep for the case? Did you talk to Mr. D'Angelo? Yeah, I talked to him several times. Did you talk about your prior statement? No. Did you read your report about what they said you said? No. What I told Mr. D'Angelo was, wow, these families could have done that to that family. Now, she said, I went up that street for years, and I saw Stanley out there cutting his lawn. Following and towed behind him were his two daughters, with their 21 year-olds following their dad cutting their lawn. He's got a family, he's got little kids. I don't think he could have done that. The prosecutor stands up and says, well, you didn't see the video evidence, did you, ma'am? No, she didn't see the video evidence. She lives in that neighborhood. She saw Stanley. She saw Stanley with his family. I don't think Stanley could have done this. Please, I implore you to hold the state of Ohio to that burden of proof. And if you do in this case, and not get strung up on, well, someone's going in that house at this point, and this alarm's going off. When you look at the totality of the circumstances and the facts in this case, there's reasonable doubt all over it. And you can leave that jury room, you can let this judge know that you've reached a verdict when you're ready, when you're good and ready. You can come back out here and you can say, Mr. Ford is not guilty of these crimes. And you can keep your head up and walk out of here proud of the fact that you held this state to its burden of proof. You upheld the Constitution in doing so. It's not guilty, folks. Thank you for your time.
Thank you, Mr. Gorman. Mr. LaPrenzi? Sure. All right, we're just gonna, do you need to, let's do this. Anybody need a break? All right, well, that seems to be the general consensus of this trial, isn't it? Okay, we are gonna go ahead and take a 15-minute break till 4 o'clock. Remember the admonition I've previously given you, don't talk about the, hold on, let's not lose focus. It's imperative that you not talk about the case amongst yourselves or with anyone else. This includes family, friends, and the media. Do not post or read anything about this. Do not discuss it amongst yourselves or with anyone else, and do not permit anyone to discuss it with you. You may think you've received everything, but you haven't. You haven't received the last part of closing argument by the state, and you have not received my final arguments. So we'll take a 15-minute break. You'll be back at 4 o'clock, and we'll finish with closing arguments and instructions.
All right, please. Notepads faced on any chair. County Court of Common Pleas is again in session. The Honorable Christine Croce presiding.
Thank you. You may be seated. All right, Mr. LaPrinzi, you may proceed.
Thank you, Judge. So, it's not lost on me that when you knew I had to get up and do rebuttal, that I didn't hear the mental sigh from the room. I get it. You've been doing this case for over a month. You've heard things over and over and over again. I understand that, and I appreciate that. I will try and keep this as brief as possible. However, I think that Mr. Gorman's pointed out, you understand the importance of this case, and that I have duty to the citizens of Summit County. And so, you know, I always kind of harken back to the thought, and I often say when, you know, I graduated from law school, you know, my big dream was to get up in a case such as this and do a closing argument and really change your minds and convince you of the guilt of the defendant. But as I've gotten older, I realize that's not the goal. The goal is really that I waste your time and bore you for the next so many minutes because the evidence spoke so strongly to you that you didn't need me. The problem is I can't ask each one of you at this moment, okay, so how are you on this? How are you on that? What do you think about this? What do you think about that? And so I feel like I have to get up and at least try and make my arguments to you in response to Mr. Gorman's arguments, just in case. And even if I say something that you might think, okay, I get it, you're beating a dead horse, the person next to you may not. And so it might help them just a little bit. So please bear with me as I know I'm the last to go, and I really do understand that, but I do think it's important. Mr. Gorman, I know, ended on a very emotional thought, which he talked to you about Audrey Taylor and what she said. He spent a lot of time, actually. He didn't just spend that 1 second and say, you know, she said, I don't think he can do it. He did it. Now, we all know that's completely irrelevant in this case, right? What Audrey Taylor thinks of whether Mr. Ford did it or not is absolutely irrelevant. Just as irrelevant as when I asked Detective Looney, what do you think? Do you think he did it? Or if I asked any other witness, it's completely irrelevant. It's nice, it's good to close on, it's emotional, but you know, there's other people in that neighborhood who walk up and down those streets we can't ask, and we all know that. And that's why it does not matter. It's irrelevant what Lindell would think, or Gloria would think, or Dennis, or Angela. It doesn't matter. Not here. Not today. So it's my job now to kind of respond to what he said. He spent an hour and a half. I'm going to tell you I'm not going to spend an hour and a half re-arguing every point he made. I'm going to ask if there's something that he said that I don't respond to, but you're maybe thinking about, that you use your common sense, rely back on the evidence, and use that to figure that out for yourself. Because we believe, the state believes, that if you use your common sense and reason, you will ultimately be firmly convinced that Stanley Ford killed 9 of our citizens. One of the things that I think is interesting is that Mr. Gorman, throughout his closing argument, used the phrase, "it doesn't make any sense." Why would somebody take the shoelaces out of the shoes that they got thrown into the trash? Well, ladies and gentlemen, as you can tell in this case, just starting from the whole reason we're here, does it make sense to torch a house with a family of 7, including a 1-year-old baby? Does that make sense? Under what circumstance in our world does that make any sense? It doesn't make sense. And so what the person who does that, what they do, may not make sense either. So just because there's certain things that Mr. Ford did that we don't understand doesn't mean he didn't do it. Because what we do know is that killing 9 people, 5 of them children, doesn't make sense. So that should not excuse or explain away that he didn't do this. One of the other things that is kind of interesting is that Mr. Gorman spent, I would say, probably 75% of his argument on alternate suspects. And I get it. I get it. You can only argue with what you have. And the fact is that there are a lot of alternate suspects. There are a lot of motives. I'm not going to tell you that the witnesses you have, if you're, in hell, that's who you have devils for, whatever you said, I don't even know, because I never used it. But the fact is that in this case, we have a situation where Mr. Ford felt like he was an angel. He told people that. And Mr. Gorman kept using, well, Mr. Ford said this, and so therefore he said, he corroborated the fact that there was a black car, things of that nature. And he would rely on Mr. Ford's statements when he made his arguments to him. And it was interesting because in Mr. Ford's statements, he said opposite things all the time. You didn't see me coming in the house, I was asleep. Okay, I was coming in the house because if somebody was coming in the house, it was me. Right? He says, I used my red wing boots to cut my lawn until he hears that they found some sneakers. Oh, what type of sneakers? Oh, New Balance. Oh, yeah, I cut the lawn in New Balance, which, by the way, Mr. Gorman brought out for you. I'm not going to bring them out again, but if you look at them, there's no grass on them. So Mr. Ford seems to deflect, as Detective Looney's told you. And in his deflection, you can see his attempts to avoid. And in this case, even in their closing arguments, the defense's deflection is to avoid. Because even in that, Detective Looney is really smart, but he's incompetent. It's always whatever suits their need at the moment. The evidence in this case isn't like that. You will never hear us suit our needs by the moment. It is the evidence. And the witnesses with their foibles are the witnesses, and nobody's explaining them. Nobody is saying that there is something they are not, or that they didn't say what they didn't say, or that they did say what they did say. The fact is it's the evidence that we rely on. So he spent 75% of his time on our alternative suspects. And I guess I would too, because they got a lot of motive, right? I mean, let's all be honest. We've said that from the straight. Boggs. He would be a prime suspect. Spouse, significant other, always a prime suspect, right? They talk about the pressure to arrest. There's such pressure to arrest. Why didn't they arrest him? 4 days afterwards, he supposedly gave a confession. Is it because they're so incompetent that they had a confession from a guy who had a history with this woman that they wouldn't arrest with such pressure? Or was it because they're not incompetent? And it's because they looked at the evidence and made hard decisions about the evidence and who it is that did this crime. Mr. Gorman and his voir dire talked to you a lot about the elements. He wanted to make sure you all understood that if we missed one element of any of the charges, it's a not guilty, and he's right. But you know it's not an element? Motive. So what he has done is, for 75% of his argument, talked about motive. So all these people that he's talked about have motive, but not one lick of evidence, not one little bit of evidence that any one of those people committed this crime. Macklemore, Ronald, I can't even list them all, Francine Lewis, any of them. The only thing they had is motive. They talk about, oh, he was seen there 2 days before, or this person had lied because he had been there. That doesn't put them there the night of this crime. So I'm going to try and make this a little bit easy for you. I'm going to suggest this to you. You saw the video. And in that video of May 15th, 2017, In that video, we're going to go backwards. We're going to deconstruct this. Reverse engineer it. On that video, you see on the porch of Chester Williams a flash. That's the accelerant igniting on the third attempt. 693 volts. I think it's pretty clear that that is when the house is set on fire and it catches. 20 seconds later, after we see that flash, we see an individual running up the street. If you are not in the situation where you go back in the jury room and you aren't firmly convinced that that is the person who set that fire, then I'm done. I'm done. Because I'll never convince you anything else. If you believe and firmly are convinced when you go back there that the person running up the street 20 seconds after the fire is started is the person, then all we have to do is figure out who that person is. That's it. And that's what Detective Looney told you. He told you he was convinced of that. And therefore his investigation focused on that. And what he did was he focused on the person going up the street. And if you look at that same person, where does that person go? They go to 1374 Hillcrest. And they appear to go into the house. And the alarm codes are going off and being set. And then minutes later, you see a person coming from that house, out of the house, walking next door to what address? 1370 Hillcrest. And if you were the detective in this case, what would you say? You'd say, hey, all we have to do is find out who is in that house. And the case would be solved. Regardless of whether Mr. Boggs tried to set Angela on fire before, what difference does it make if we watch the guy who set the fire go into the house? Because it's who's in that house. And this is where Mr. Gorman's reliance on his client's statement comes in, because who does he say is in that house? Nobody but him and his wife. And if you look at the videos, I don't think anybody here is suggesting his wife did this. So all the noise that we heard about all the other suspects and all the other drug people and all these other things is just noise. Because we know, again, if the person running up the street is the person that set the fire, then you just have to figure out who's in that house. And that's where your common sense and reason comes in. Just like you can contort your mind and do mental gymnastics all day long to say, well, listen, you could be somewhere without your phone. Use your common sense. When was the last time you were somewhere miles and miles away without your phone? People don't do that. That's the ordinary common sense stuff. It does happen. I've left my phone at home, right? But here's the situation. Would it happen to be that Mr. Boggs left his phone at home while Mr. Ford is out and about doing all the things that he says he was doing, getting lemon balm and moving TVs, although he says that the TV was moved way, way before? It doesn't make any sense. And Mr. D'Angelo, I think, did a great job of telling you and explaining to you possible versus reasonable. Reasonable. Who is in that house? The only people in my house are me and my wife. Who has the key code? Me and my wife. Nobody else that I know. Who has keys to the house? Me and my wife. Not Stanley Mitchell. He's a convenient person because he's related to him, and they could make you or suggest to you somehow that maybe he's protecting his son, but we know that his son doesn't look anything like him. He's 130 pounds, 6 foot tall, and anybody who watched that video can tell that the person running is not 130 pounds and 6 foot tall. It's a husky individual. And that's why we said if he is involved, it's only because his father did it. And now they want to come and say, well, we know somebody did the alarms because he was in custody. Well, we all know that he told his wife and his son to go do it. He didn't say that they didn't have the code. His wife has the code. She could have given it to the son, but somehow that's now evidence that his son may have done this. Common sense and reason. Do not do mental gymnastics to try and fit an unlikely circumstance into their argument. The fact is who lives in that house, who has access to the house, and the only person that fits the build, shape, and access is Mr. Ford. That's why we also do the side-by-sides. So you for yourself, as you know, not one person took that stand. We didn't ask one person on this stand their opinion about who did this crime, who was in the videos. Not once. Because you know why? As Detective Mooney said, I'm not the finder of fact, you guys are. And he's absolutely right. He's absolutely right. And so that's why we give you the tools and the information you need to be able to determine if Mr. Ford is the man running from that fire. So that talks about the fire. I told you we're going to deconstruct it. And I'm not going to go into a huge amount of more detail, but the fact is if you work backwards then, what are the commonalities? Detective Tanisha Stewart is incompetent as Mr. Gorman wants to say she is. And she might not have been your favorite witness, but the fact is she said one of the most important things, and that's commonality. What's the commonality that's lacking in all the other suspects? There's nothing to tie the three of them together, yet we know the two in the video, clearly the same person. You can see it. You can see how they walk. You can see what they're wearing. Same person. It's the commonality. Same going to the house. Same using the panel code. They want to tell you that the alarm codes are often used during the nighttime. Well, I looked at that. You'll have it, and you will see that there's only about 9 times that the alarm code is used in the middle of the night. 9. 3 of those were the nights of the fire. That's over about an 18-month period. That's pretty good odds. As a matter of fact, those are such good odds, I would think maybe we should go look for other fires those nights. But the fact is that it is not as much as they want to say, oh, he's always over there. He's always doing this. And again, of course, they want to admit, oh, he's there doing it, but at the same time, well, he wasn't doing it that night. You can't have it both ways. Things like in their arguments, and I hope these are the things you're picking up on. The dog hit on Boggs' socks, not his shoes. Why would we test his shoes if there's no hit? We test on the things we find. We don't waste time. We don't have time to do wasted testing. Mr. Gorman puts us on, puts the burden on us, which absolutely is beyond a reasonable doubt. It's firmly convinced of the truth of the matter asserted, and that he is the one that committed the crime. That's what we have to do. And he is right, it is used in traffic offenses. It is a reachable burden. But it's interesting how when he was arguing, and Tanisha Stewart, of course, the judge will tell you this is your memories. Tanisha Stewart didn't say anything about suspension that I recall, and of course it's your memory. What she said was, I thought it was a truck because the lights were higher and the length of it was longer. I thought it was a truck, but I don't know. That's what I recall, she said. But somehow it's all of a sudden that, she said about suspension and it's a truck and it's absolute. And then what did Mr. Gorman tell you? That the person who set the fire in the first 719 Fultz fire went and got in that truck. There was no evidence of that. Tanisha Stewart thought that might have happened, and she put that in a report originally, until we got the videos and saw the movement between the houses and around the houses on the side of 1374. And she told you, look, after I found all this out, after I saw the alarm stuff, after we figured this all out, hey, things changed. Which, by the way, let's not fault Tanisha Stewart for not succumbing to the pressures to arrest, right? I mean, that's what they're saying. All this pressure, and they focus on just Mr. Ford. Well, that's not true. They focused on Mr. Boggs first. They actually arrested him. Tanisha Stewart felt she didn't have enough, and she didn't do it, and somehow that makes her incompetent. We get additional evidence. Detective Looney's now on the case, and together, and with others, they realize there's a lot more. If you believe, again, the person going up the street 20 seconds after the fire is 693 volts is the person who set the fire. And you see that person going into the house, and we know who's in the house, we know who has access to the house, and it's Stanley Ford, and he tells us that. With that information and that MO, it's not hard to look at the 719 volts case and make the same comparisons based on the commonalities of the two. They're wearing the same type outfit. They go to the place 3 times. Now maybe that's just because he couldn't get it set. But the fact is he goes there 3 times. And each time he runs back toward his house. Commonality. Alarm codes. Now in that situation, you will see in the alarm code that he does not come out. He goes into the house, and the alarm's not set until 6:03 in the morning. Keeping in mind, his wife gets up and leaves to go to school at 6:30. So at 6:03, he sets the alarm to that house again. You heard the evidence about the January 23rd fire. And in that situation, again, what do we hear? We hear Mr. Ford, number 1, is told by Miss Ewing that a car in her driveway's windows were knocked out. She talks to him about it, and he says what? I think Anthony did it. What happens then? Shortly after that, Anthony's truck ends up being on fire. Also happens to be that Anthony is with Nyjah Sands, whose son also had an issue with Mr. Ford. And so the truck that belonged to them ends up on fire. And what do we know? 3 minutes, 4 minutes before that fire is reported, Mr. Ford is hitting his alarm. Commonality. Let me go back to one other point. Mr. Ford struck in the 719 Fultz fire. We saw, you can actually see it. It's eerie. You can see the man with his back slightly turned to the camera, putting the lighter fluid on the side of the house. He lights it. It doesn't go. We heard testimony that lighter fluid is a medium petroleum distillate. Right? And that's what they find on the side of the house. I think it was numbers 1 and 10. The person leaves, the fire goes out. You will then actually see the person over in the other house, his mother's house, looking around the side of the house, looking out the front door as though during this time period to see, did it start? Did it start? And then he goes back, and on the 3rd attempt, he actually lights the porch. And what do we find in the porch? Gasoline. Not a medium petroleum distillate. So what does that tell us? That tells us that maybe the person who set this fire had access to multiple methods or accelerants, such as his mother's house. Where if you look at the photographs of the search warrant of his mother's house, it's like a shed. It's got gas, it's got lighter fluid, it's got everything you need. I would think that if Mr. Boggs drove all the way from Ravenna or Portage County, that he wasn't bringing several different types of accelerant to start this fire. It was somebody that failed twice and said, you know, that didn't work. Maybe I should change it up. I'll use gas this time. He used his mother's house as a home base. And that's where he did all 3 fires. Coming and going from that house to his house to the fires. If you also notice, and I know Mr. Gorman, I don't know if he meant it or not. The fact is that Mr. Ford, this is a transcript of his statements. You can imagine that there's a lot in here that's just talk, that's not relevant. And so we give you what we felt was the important parts of that. So please don't, just because he says, you're only going to get to here, you can't use that evidence as evidence. Just like if I got him and says, we're only giving you 15 minutes, but I wish you could hear the rest. That would be improper, right? Because I'm implying something to you that may not be or may be true. There's many reasons why you may not hear the rest of that statement. The fact is you have to ignore that. And I said in voir dire, you can only decide a case on what evidence you have. If we didn't bring you the evidence and you don't have it, then you don't have it and we don't get the benefit of it. The evidence we bring you is what you have to make the decision in this case. And it's the state's position that this is more than enough to get you to firmly believe that the defendant committed these crimes. And please, I apologize, I'm skipping around trying to make sure that I cover all the different things I want to respond to Mr. Gorman. So, ladies and gentlemen, one of the other things that Mr. Gorman talked about in that interview is he really pointed out Mr. Ford versus Detective Looney and somehow suggested that his client wasn't very bright. We don't know that. You don't know that. Obviously, Detective Looney, he testified about what his educational background is. It is obviously highly educated. Just because a person isn't educated, and we don't know what Mr. Ford's education level is, and that, I'm not here to argue that. The point is you don't have to be educated to be smart. And the fact is that Mr. Ford actually was kind of smart. Because what he was doing initially was deny everything, gather information. If you listen to the interview, especially those very first ones, he is trying to gather information from the detective so that he then can respond, just like with the sneakers. What do you use? My Red Wings. What'd you take? Sneakers. What type? New Balance. Oh, I cut in New Balance. And he's adjusting his arguments. You did not see me coming out of my house because I was asleep. I have evidence of you coming out of your house. Oh, well, if I was getting lemon balm. And he would adjust and adapt throughout the interviews. The one thing he couldn't do, though, and you will see it in the interview, and quite frankly, I'm not sure why. And again, I don't know why what he does doesn't make sense. He has been told, and Mr. Gorman put this out there clear like it was a bad thing, that they got him in that room, chained him to the table, and told him, you've been charged with 9 counts of aggravated murder. All we need you, Mr. Ford, to do is tell us why you were down the street. And he couldn't. The most simple of all questions. And if he was innocent of setting that fire, and he wasn't the man who ran 20 seconds after that accelerant exploded, if it wasn't him, why isn't he telling us why he was down And initially, you know, when I was thinking about it, I was like, man, maybe he has an affair. Maybe he was getting drugs. They gave him the opportunity to say that. And he said no. And then you might say, well, heck, you know, he still didn't want to, you know, he's still married. Who in the face of 9 aggravated murder charges doesn't tell you, hey, listen, I was having an affair with a lady down the street. I was hooked on drugs. I was gambling. Whatever it is. Instead, Stanley, make sense of this. Tell us why you were down the street. Can I go down the street? Is that the response of an innocent man? It is not. Ladies and gentlemen, I just want to double check my notes here. One of the things, and I will tell you, maybe prophetic, maybe Mr. Ford should have listened more, I don't know. But in his interview with Tanisha Stewart, the very first time he meets, I think she's with Sergeant Lee in 2016, after the 719 folks. In his conversation, they're talking to him about, hey, listen, your name came up because of your relationship with the people over here that died. And they talk about that relationship, and Mr. D'Angelo went over the statements he made about them being bad people. But one of the things that kind of gets glossed over in his statement is that he says at 3:16, 3 minutes and 16 seconds in his interview, he says, my wife always encourages me to not even bother them because they are bad people and God will take care of them. That was an interesting statement that he made to the police that day. In light of the statements he's made to other people about him being an angel sent by God to watch over his neighborhood. At 10 minutes and 30 seconds, he says, my wife says, the devil is busy. It's real easy to get caught up, and once you get caught up, you get caught up. And ladies and gentlemen, I'm not sure why his wife is telling him that in regards to his neighbors, the ones that he was having problems with. But maybe she foresaw what was in him and was warning him to stay away and let them be. But he couldn't. Just like he couldn't stop talking, he couldn't listen to his wife, and instead of getting caught up, he got caught. And here we are today. And ladies and gentlemen, I'm just asking you, on behalf of the state of Ohio, I ask you to, this is a big case, serious case, obviously we know that, and we would expect you to look at every piece of evidence, look at every video, whatever it takes to give the defendant every single benefit of the doubt by looking at everything. But use your common sense. Test it. And when you do, at the end of the day, you will find that the man, and be firmly convinced that the man that's running from that flash, that runs to 1374, then to 1370, is none other than Stanley Ford, by his own words. And we would ask at that point in time that you find him guilty of all the charges. Thank you.
Thank you, Mr. Prince. All right, ladies and gentlemen, we're now on page 67 of the jury instructions, if you want to follow along. You have now heard closing arguments. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. Evidence was received about the commission of 3 separate fires and the charges associated with each fire with which the defendant is charged in this trial.
that evidence was received as to each specific offense or offenses charged relating to each separate fire. The evidence was not received, and you may not consider it, to prove the character of the defendant in order to show that he acted in accordance with that character. If you find that the evidence of one of the fires is true, and the defendant committed that fire, and the offenses associated with that fire, you may consider that evidence as it relates to the remaining fires only for the purpose of determining whether such evidence proves the defendant's motive, plan, and/or identity. We call this other acts evidence. Motive. You can consider evidence of one fire that shows motive or that establishes that the defendant had a specific reason to commit the other fires charged in this case. Plan. You may also consider the evidence of one fire to determine whether it is linked to the other fires because the acts carried out in the furtherance of the same overall plan. Evidence of a plan or common design refers to a larger criminal scheme of which the crimes charged is only a portion. You may consider evidence of a plan if it supports the identity of the person who committed the act. Identity. You may consider the evidence of one fire to determine whether such evidence proves the defendant's identity. You may also consider the evidence of modus operandi to determine whether the evidence proves identity. Modus operandi means method of working. It is evidence of a signature, finger-like characteristics, unique enough to show that the acts in each fire were committed by the same person. Other acts evidence cannot be considered for any other purpose. Words and phrases. Words and phrases shall be read in context and construed according to the rules of grammar and common usage. As to any definition which contains the name of a specific victim, you shall substitute the name of the specific victim for each corresponding count. In your deliberations, you may not discuss or consider the subject of punishment. In this phase of the trial, your duty is confined to the determination of whether the defendant is guilty or not guilty of some or all of the crimes charged. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions of the court to your finding, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence. Make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fully and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view, you are instructed to disregard it. Now, your initial conduct upon entering the jury room is important. It is not wise to immediately express a certain determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you decide you are wrong. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should not surrender an honest conviction in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. If during your deliberations you have a question regarding the evidence or the instruction of law, it will be necessary that you prepare your question in a brief written form. The bailiff will deliver your message to me, and either a response will be sent to you or you will be returned to the courtroom for further instruction. As I previously instructed you, no juror was required to take notes. The taking of notes was entirely a matter of personal preference for each juror. The fact that notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of jurors who did not take notes. One of your first tasks upon entering the jury room for deliberation is to elect a foreperson. The foreperson will see that your discussions are orderly and that each juror has an opportunity to express their views, discuss the case, and to cast his or her vote. Otherwise, the foreperson's responsibility or authority is the same as any other juror. The court will place in your possession exhibits admitted into evidence in the verdict forms. The foreperson will retain possession of these records, including the verdict forms, and return them to the courtroom. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberation or the nature of your verdict. This order must be strictly obeyed. The verdict forms will be in this envelope or this folder, and you'll be given them. Each one of them has a verdict number on them, and then in parentheses under it is the victim's name. And that's really for you for purposes of just keeping them organized, and so that you can refer back then if you need to the jury instructions and what count that is. There's a place for you all to sign your name next to your number. That's the number that you're currently sitting in, not any of your old numbers. They also need to be dated on the date that you sign the verdict. Now, there's additional instructions at the bottom of the verdicts for the charges, which will instruct you on whether or not you're to consider the specifications. And it'll indicate to you, for example, in verdict form number 1, if your verdict is guilty to aggravated murder on count 1, you must complete the following verdict forms for the aggravated murder specification to count 1. If your verdict is not guilty to count 1, you will leave blank the verdict forms for the aggravated murder specifications to count 1. And then it's the same thing for specification 2 to count 1 and all of those. So there's varying instructions as to each count. They're pretty self-explanatory, but you'll only proceed if you find him guilty of one of the underlying charges before you consider those specifications. If it's not guilty, you will not consider those specifications. If you have any questions about those, you can put those in writing and we'll do our best to answer. I want to talk to you a little bit about questions. I will not answer for you what someone testified to. That's your job to rely on your collective memories as to the testimony. We will not read back portions of the transcript because, again, it's your duty to rely on your collective memories as to what the evidence will be. So those are some questions we usually get, and those are ones I will answer. I mean, I'll answer you until you know, but I'm not going to do what you're asking me to do, and that's typical. And so I just kind of wanted to give you a heads up. You have to talk amongst yourselves and remember together what that evidence is. So we're back to the documents now on page 71. Should you wish to take a break, you may do so at any time. However, you must summons the bailiff so that you can be released to take your break. When it is concluded, the bailiff must be notified it is concluded so that the bailiff knows you have started your deliberations again. During any breaks during deliberations, any documents related to the status of your decision must be safeguarded and secured so as not to disclose the status of your deliberations. All of your deliberations shall be held in the jury room. You must not discuss the case with any of your fellow jurors while on any break or outside the jury room. You may only deliberate when all 12 are present in the jury room. After all, and I repeat, all 12 jurors agree upon a verdict regarding the counts and specifications in the indictment, fill out the verdict form or forms that correspond to your decision. Each juror must sign each verdict form in ink by the number that corresponds to your current juror number. Date the verdict form on the date it is signed by all 12 jurors. When you have reached a verdict as to each count and specification, notify the bailiff. You will then be returned to the courtroom and your verdict will be announced. You will be sequestered during your deliberations in the trial phase of this case and if required overnight. I provided each of you a sequestration admonition, which I have filed and which explains the sequestration process. It is impossible for the court to determine the length of time that your deliberations will take. Take the time which you believe to be appropriate to thoroughly and carefully review all of the evidence and other information provided to you. Many of you have cell phones and other electronic communication devices. You are not to bring your cell phone or any other electronic device while you are sequestered. If you do, the court will hold those devices in a secure location until your verdict has been read in open court. You are to reach your verdict based solely on the evidence and the testimony presented to you in this court according to the instructions I have given you. Those of you selected as alternate jurors to serve on this jury panel, you must remain and be sequestered until the jury has returned its verdict in open court. A juror selected as an alternate is not permitted to participate in the jury's deliberations unless one of the deliberating jurors is found by the court to be unable or disqualified to perform his or her duties. You will remain in the visiting judge's jury room and apart from the other jurors and remain under the direction of sworn staff until the verdict is reached. The alternate jurors will not accompany the jury to the jury room or participate in deliberations. The alternate jurors continue to be part of the jury panel while the other jurors are deliberating until you are fully released from this case by the court. You shall not discuss this case with anyone or to each other or tell anyone how you would have voted until you are fully released from this case by the court. Jurors 1 through 12 will now retire to the jury room to deliberate upon your verdict. The bailiff will confer with you regarding any recess or adjournment. And then for tonight, the visiting or the alternate jurors this reads, will now return to the visiting judge's jury room, but because it's after 4, Ruth, who's been helping you on all the breaks and who's in charge of the food and all of those things, she will take charge of the 5 alternates and put you somewhere where you can have access to a bathroom and those types of things. Before I read this last paragraph, I just want to talk. So we ordered food. It's going to be here at 5. So what I would suggest is go into the jury room, select your 4-person, and then if you want to eat while deliberating, we'll take you down and get your food. You come back and deliberate. If you want to take an hour break or a half-hour break just to eat and not talk about it, then everybody will go downstairs and eat dinner. So why don't you just go in there, you'll select your 4-person, and then you'll let Ken know what you've decided about dinner, okay? So I want to thank you and express my appreciation as well as that of the parties for your service as jurors today and throughout the last 5 weeks. By providing this service, you have contributed toward continuing the unique system of justice which we enjoy in this country. And so with that, we are adjourned. So also too, you now may take your notes and your jury instructions. The alternates, I want you to leave yours upside down on your seats. We will collect them. If there's a need for you to replace one of the other jurors, then you will have your notes at that time. What did you say?
Yeah, backwards, you take the alternates.
Okay, excellent. All right, we're adjourned. So the 5 alternates just remain. Yes. Yes, you may. And then you'll meet her out there in that way. Okay?